I back to item number, mention item number, last item supplementary 19, 20, 21 for
Yes.
hearing. So
Three
maybe,
items are there.
my lord,
Yes.
my senior friend is there.
My lord, it has come at our instance. My lord, it has been pending for a long time. It was fixed for hearing the last year.
Yes, 12.
I filed in a year 22, my lord. So I wait only 2 weeks time because I didn't to prepare. Only 2 weeks time. my lord.
No, it's a matter of 5 minutes. The case of my learned
Yeah.
friend is that, my lord, there is no question of law. Forget about the substantial question of law.
Although my lord,
Now, what they are saying,
Against WC.
my lord,
yes,
now
MFA.
they are saying that in the license, there should be PSB endorsement. Now, the law is that in the transport itself, it inbuilt PSB endorsement. Therefore, it's not required at all. This is a finding of the learned judge. So therefore, I do not know how come the substantial question of law comes in. And it has been pending for more than 1 year without paying anything.
My lord, fixed a date,
Let
my lord.
it come on 14th. If
My
my
lord,
learned
14th,
friend
I
has
have some
any difficulty
difficulties.
today.
Okay, we'll accommodate for him for the day, but we'll.
22nd, my lord, fixed.
We'll
I'll
have
be-
it on 17.
17 is little difficult. I have 2 case fixed also hearing.
My lord, it's not that
22nd, I'll do it, my lord.
such a huge.
22nd.
That article 370 is being.
Only
filed
my
here.
lord, 12 days I am seeking.
He treats all cases at 370. At par.
Anyway, my lord, it's
Second,
No case is inferior.
it's a lordship
Represent time
convenience.
is the same.
My lord,
lost. My lord,
Okay, 22nd.
22nd.
27, all right.
Request for adjournment has been made by Sri R.C. Pal, Learned Counsel for the appellant insurance company, which however is registered by Sri S. Datta, Learned Senior Counsel for the claimant.
Yes.
Considering the above, Kumar. So the matter is adjourned, Kumar, that it will be listed on 22nd of August
Much obliged
for hearing.
for hearing.
I believe on that date, my learned
Yes.
friend will oblige me.
If I leave. My lord,
We haven't seen the future.
my lord.
Well, in CRP is one CRP, my lord. Interim order has given, my lord. And because of this said interim order, I'm not receiving the family pension, my lord. Second I filed this case, my lord. So,
You have come for vacation, modification.
yes, my lord.
Is the CRP is of which year?
CRP 23, my lord. 5/6/23, it is
Okay, 21.
any date subject to lordship confirmation. Next week, my lord.
Next Wednesday.
Yes, my lord. 16.
May I please, your lordship, I beg to mention for listing of withdrawal for tomorrow, WPC 6518/2021.
WPC will not come before this.
Okay, which court, lordship?
We do not know what is the decision about. This is bench one, only civil matters.
Lordship.
You consult your colleague and they'll.
May I please, your lordship? My lord, I beg to mention item number 12 and 13, my lord. With due consent of the other side, my lord. On behalf of Mr. G. Bokulia, he is personally difficulty today, my lord. So I pay for only password for the day. Only for the day, my lord. I've taken consent from the other side. 12 and 13.
12 and 13. You are making a mention on behalf of Mr. Bothakot.
G. Bokulia.
G. Bokulia.
Yes, my lord.
Yes. Madam,
Yes,
you are appealing.
lordship, here lordship, the appeal is already disposed of. They have filed a cross objection. So I pay
You
for,
filed a cross.
they have filed a cross objection.
Okay.
So I have already given the file to my client lordship. So let it be after 1 week lordship so that I can collect that.
Okay. A prayer for adjournment has been made on behalf of the appellant. On behalf of on behalf of the G. Bokulia, Learned
Cross
Counsel
object.
appearing for the,
Cross objection.
this will be an appeal after all, for the party filing the cross objection. And you can cross objection. Better. Also heard MSM Chaudhary, Learned Counsel for the insurance company. Also, Sarah has agreed to list on
Next week.
My lord, next week, my lord. Next week.
list after a week. This will be in 12 and 13.
12 and
12
13 are
and 13,
analogous
madam.
matter. Lord. Must
Highly
oblige.
appreciate.
May it please your lordship.
Yes, Mr. Roy, anything?
Not item number 15, well, unnecessary is there.
15,
Yes, madam.
yes.
I'm praying for a week, madam.
15, you are for whom?
I am for the claimant, madam. Yes, ma'am.
Lordship,
Madam,
in
you
this
are-
case, I am for the appellant lordship,
Yes, ma'am.
united. And I think you are for the respondent claimant.
Yes, ma'am, I claim.
You want some time?
Sometime, madam.
Right.
1 week, madam.
On the
Any-
prayer of 3A Roy Leonard Council for the respondent claimant. Matter is adjourned by a week.
My lord. Okay, can I pray for a date, madam? Any date?
List. Also heard M. Chaudhary. Leonard Council for the appellant is British company. Para list on. Hello,
Any date, madam?
we'll have it on 24th of,
15,
24th, madam.
24th of,
Yes.
the Thursday,
Yes, madam.
24th.
Yes.
lordship.
Oblige.
This will be 15. Item 15.
Yes, madam. Oblige.
May it please your lordship. Lordship, I beg to mention an item for listing, your lordship. It's an MSC appeal, your lordship, of the year 2022, 2020, your lordship. May I pray that the matter may be listed on the next week in the next.
What is the stage of the case?
Lordship, it has been already admitted there was a delay. IO was filed, it was already admitted, and since then it has not been listed. Your lordship.
Okay, we'll have it in the next week,
Yes, your lordship. Any date, your
next
lordship?
Friday.
Next Friday. Deeply appreciated.
Okay. Couple of- Yes,
Mayor, your lord. My lord, I am the plaintiff appellant. And in the present appeal, I,
madam, have you seen? We'll take for disposal.
Lordship, I have received instruction also. May I place?
Let him place the case, then
Lordship, already he has taken undertaking to the department in 2015. So may I place this?
have you shown it to your friend, to your colleague?
not undertaken.
No, Lordship, today morning I have
No,
received.
no, you have Mr. Sharma have a look at it.
Yes,
I don't have that.
yes. Which reference that money execution. Yes, Lordship, may I?
This is regarding my lord, money execution. I will submit upon that. My lord, the suit was partly decreed. So for that, the money execution was started. Then they made me the full payment. So I made the undertaking that I will not execute further the money execution. It is not that man. And here in this appeal, my lord, I have,
When is this undertaking of which year?
This is 2015.
This they had instituted in 13.
yes. And the suit was of 2009,
No, this RFA is of the year 2013.
13.
So there is an undertaking of 15.
Yes.
Will it not cover this
No, no,
subject
no,
matter?
no, not at all, my lord. I will come to that, my lord.
Now, let us have a look. Madam, can you hand over the
Yes, Lord.
instruction?
Yeah.
Or not?
with a copy of it, I can give. Anytime.
Education test.
Money
আৰু
exhibition.
কেছ আছে নেকি?
না না সেইটোৱে আছিলে
অ।
আমি যে পাৰ্ট ডিগ্ৰী আছে তাৰ কাৰণে মানি এক্সিবিশন চলাইছিলো সেই মানি এক্সিবিশনৰ পেমেন্ট
এইটোতো আপুনি RF টো ক'ত দিয়া নাই?
আৰু চেক নালাগে এইটো কাৰণ সেইটোতো পাৰ্ট ডিগ্ৰী হৈছিলে এক মিনিটৰ ডিগ্ৰী কেতিয়া হৈছিল ডিগ্ৰী 2012 ডিগ্ৰী হৈছে
অ, yes.
Are you on instructions to press this appeal?
my lord the present appeal is against
Are you instructed to press this, continue to persist with this appeal?
no it is not that my lord
Do you have the instructions to persist with the appeal presently?
this is the new I could not go on under this because
No, when did you have last contact your client?
before 10 days
No, are you instructed to press with the appeal or are you, can you get the information from him regarding this?
That's
because
my
so
information.
far my information goes, my lord. This execution was started on the basis of the judgment which was passed in 2012.
Yes, Lord.
No, we have understood your matter. It was
Yes.
partly declared he had gone for execution and the execution case, they have paid the amounts, they have given an undertaking.
Yes, my lord.
But the understanding of the department is that
Yes,
by paying the state amount, the
yes.
entire matter has been settled.
Then I will take the
You
instruction.
take
my
the
lord.
instructions.
Yes, yes.
If unnecessarily you are not pressing, then there is
But,
no point.
I will request for one copy of
Oh,
that.
definitely.
Otherwise, if he is not too much interested in this proceeding,
Yes.
there's no point wasting our time. You have the instructions.
My lord.
Give a copy, madam.
Lord.
Heard. MS, heard J. Sharma, learned counsel for the appellant. Also heard MS. Sharma, learned standing counsel, Public Works Department. Prepare. This court on the last two occasions
The town state of America. No, this is-
had directed MS. Sharma, the learned standing counsel, to obtain necessary instructions in this case, which is pending since the year 2013. Para. The learned standing counsel has submitted that written instructions have been received from the department by way of communication dated 7/8/2023, from which he submits that it appears that the matter has been settled between the parties. Para. MS. Para. Sri Sharma, learned counsel for the appellant, however, submit that he does not have the latest instructions, and therefore this court is of the view that an opportunity may be granted to him to take the instructions on the standpoint, on the stand taken by the department. Para. List. We'll pick the date. List on 17th next week, next 17th, next Thursday,
17, yes.
on 17th. List after a week on 17/8/2020. Full stop. A copy of the written instructions may be handed over to Sri Sharma to enable him to obtain the instruction. Do you have a copy of this?
Yes, yes, I have a copy, Lordship.
We written this?
Yes.
But what copy you give me?
Me, please, your lordship.
E,
Lordship, P,
B,
lordship,
not R.
lordship, P.
Okay. What is there?
Lordship, the case of the petitioner is that the petitioner preferred an MSc case before the tribunal. However, the same was dismissed for default, lordship.
Okay.
Lordship, the case of the petitioner is that the tribunal had failed to exercise jurisdiction, Lordship.
Where are the decision?
Lordship decision, Lordship, it's a covered case otherwise. Two thousand eight supply GLT, page 161, Lordship.
Who's appearing for the insurance company?
Lordship, no one has entered appearance, Lordship. However,
Mr. T. Kalita was there. T. Kalita, we had made some inquiry. You know T. Kalita, he
No.
appears for his photo.
Lordship, I'm not aware of that. Lordship, in this case, Lordship, 2008 supply GLT 161, paragraph 8, Lordship.
Paragraph 8.
No, Lordship, which reads, Lordship, law is well settled by a category of decisions that an application for claim for compensation cannot be dismissed on account of default.
Correct.
If the claimant does not appear or fails to take steps or does not come forward to prove his claim,
Yep.
learned tribunal has the power to adjudicate the claim on the available materials on record on merits, and accordingly he may pass
Yes,
award
that is.
to the effect that the claimant is not.
What is the
entitled.
Supreme Court?
Lordship, Supreme Court is Lordship 2000, volume 9,
Which
SCC page 394. Lordship, it's a very short judgment, Lordship. Although, Lordship, here the matter was, Lordship, leave was granted on the same rationale, Lordship. Lordship, paragraph 3 otherwise, Lordship. Because Lordship, it has been observed that Lordship, a rigid attitude may not be Lordship taken. Otherwise also Lordship.
They have
we
been
have
served otherwise.
Lordship, we have served Lordship. On the same address, Lordship, in the MSC
no,
case, Lordship, they had appeared, Lordship, when we had
Oh,
served
that,
on the same address.
Address, there was a problem.
Yes, Lordship, but when we had sent on the same
You
address,
do one
Lordship.
thing.
Yeah.
Since we remember, there's some automobile company.
Yes,
was
Lordship,
there.
Louis Automobile, Lordship.
You do one thing. There is one council T. Kalita.
Equally, Lordship.
He appears. You serve a copy. Mr.
Lordship.
Paul also knows him.
Lordship.
He appears for,
More number to look at.
we just need his presence. We are not, perhaps will not deviate from the, we cannot deviate from the law,
Lordship,
but we want to pass the order in his presence so that there is no, tomorrow there is no
Lordship.
problem for you. Third, MSP Barua, learned counsel for the petitioner, who is aggrieved by dismissal of the claim by the learned MACT. Which one?
Lordship, MSC case number 30 of
Which one?
2020.
MACT Kamrup.
Lordship,
In MSC
Amin
case
Rao.
number 30 of 2022. It is submitted that the dismissal is because of default.
Lordship.
Also. Para, Learned Council has submitted that tribunal exercising powers under the MAC Act normally should not dismiss a claim for default as such rigid attitude would be against the objective of the legislation. Put the para. This court has, however, seen that the respondents have not appeared. So, respondents, including the insurance company, has not appeared. Put the para. Let another opportunity be granted. Let a last opportunity be granted for the insurance company to appear. Put the para, at least on. We'll have it on Thursday next.
Lordship.
We'll dispose this out. Okay, Thursday on 17th, 17/8.
Oh, Lordship, can it be on Lordship, Lordship next Monday, Lordship, on 14th?
14:22, let's see, today is Thursday.
Lordship, Wednesday, if it's in, no.
On
Indian-
21st,
Lordship, 21st.
on 24th, next Monday, on 21st. Not 21st, 22nd,
Lordship,
on
Tuesday.
22nd. You will disclose it.
Deeply open.
You take this back.
Lordship.
Just a minute. Okay. Okay.
Lordship, there's a query from the whether an order passed by the district court
Have you
under
got any
section.
change?
Lordship, in this regard, various High Court had passed, taken the various view, and under section 19 of the Family Court, there is a power for the appellate court.
19 says about any orders,
Yeah, yes, any order.
where 28 does not say about orders.
Yes,
It
yes.
is only judgment. and
Under
decree.
section 25 and 26,
Hmm.
it's strictly there.
We convert this to an revision.
Yes.
Pretty bottle current council for the appellant. This appeal has been preferred under section 28 of the Hindu Marriage Act 1955 against an order dated 14/6/2023 passed by the learned additional district judge Dibrugarh in Ms. J case number 2 of 2022 in PS number 3 of 2021 full stop. By the impugned order, comma, the appellant has been directed to pay an amount of rupees 25,000 per month as maintenance from the date of filing of the application. Before going to the merit of the appeal, comma, this court has seen that the order impugned has been passed in exercise, passed under section 24 of the Hindu Marriage Act by a district judge, by the learned, by a learned district judge. Full stop. Family court. Full stop. There. The appeal admittedly has been preferred under section 28 of the State Act. Full stop. Para. Under section 24, comma, maintenance pendency light and expense of the proceedings can be granted, and there is no dispute that such maintenance are interlocutory in nature. Para. Para no, on the other hand, comma, section 28 of the Act based on that appeal will lie only from decrees and orders. Full stop. For ready reference, section 28 of the Hindu Marriage Act 1955 is extracted here at below. The aforesaid provision, unlike the Family Courts Act, is restricted only to decrees and orders, whereas under the Family Courts Act, under section 19, appeal will lie from any orders. Correct? In view of the above, in view of the above and in the interest of justice, this court is of the opinion that the present challenge has to be in the form of a revision. Full stop. To simplify things, office is directed to convert this appeal into a revision and thereafter raise the same before the court expeditious.
Can it be pardoned?
Not part of here.
Yeah.
We could check on that. Yes. What was that? From every judgment or order. Judgment. For 24. And Hmm. Can be done. No. Such directions are in the form of an order. Such directions are in the form.
What is already allowed.
On the last occasion, your lordship has, it was already perused the order of CRP 89/2022.
Yes, madam.
Can you cover?
Yes, covered.
Who was the kind of demand? Other.
In all the three cases, claimants are different, but the issues is similarity. What you know, your lordship.
The application to set aside ex parte was itself dismissed for default.
Yes,
Yes.
Your Honor.
Thereafter,
Thereafter, we filed the restoration petition, Your Lordship.
of the restoration application,
Yes, Your Lordship.
Of the order 9 rule 30.
restoration of restoration.
No, we have filed an application under Order 9 Rule
Rule
13 for
34.
setting aside the ex
Ex
parte
parte.
order. Thereafter, it was dismissed. And then we have filed the restoration application.
Right.
And while deciding the matter, the learned tribunal had already decided the
Enter into the
application
merit
which,
of the order 9 rule 13 application.
yeah, both the applications were decided on the very day.
Yes, same. order.
Yes.
Your name, madam?
A.M. DeCosta.
A.M. DeCosta.
My name is not on it.
Your
I'm appearing on behalf of Mr. B. Kaushik.
instruct MS A.M. DeCosta Learned Counsel appearing on instruction of the B. Court. Learned Counsel for the petition. Also heard. Is 1 to 2, who? 1 and 2?
1 to 3, madam, for the claimant respondent.
P.G. Jalan for respondable
1 to 3.
for the claimant.
Yes, madam.
We'll pass up the general order, so
Yes.
it will be for the claimant. Mr. Thakia for
I am,
which insurance?
respondent number 5 in item number.
No, they give the name.
In- in that-
Respondent.
United India.
Hmm?
United India. Insurance Company.
Is the Thakia Learned Counsel for the United India Insurance Company and Sri Arti Paul for
New India.
New India
Yeah,
Insurance,
yes.
New India Insurance Company. In these cases. Full stop. The challenge is with regard to an order dated 14/10,
Yes,
1410.
14/10/2019, whereby the application for restoration
Yes, sir.
of the miscase,
30/20.
will not say the number, different miscase, which was filed for setting aside ex parte award has been dismissed for default. The learned counsel appearing for the respective parties, however, are in agreement that the issue involved was also raised in CRP number 89 of 2022, which has been disposed of by order dated 2/11/2022, which are directed for remand of the matter to be decided on its own merit, and the impute order dated 14/10/2019 has been passed. Para- Hmm. Para- the learned counsel are in agreement that a similar order may be passed in these cases. Full stop, para. Vernacular. A copy of the earlier order dated 2/11/2022 passed by the court in CRP 89 of 2022 is placed on record, which has been perused. Full stop, para. After consideration of the facts and circumstances, and after hearing the learned counsel for the parties, this court is of the opinion that there is no requirement of any fresh adjudication, as the matter is squarely covered by the order dated 2/11/2022 of this court passed in CRP 89 of 2022. Accordingly, the impugned order dated 14/10/2019 is set aside, and the learned tribunal is directed to consider the restoration application on its own merit. It is further made clear that such consideration will be strictly on the merits of the case and as per law, and without being influenced by any observation made by this court. The revision petition according to stands allowed.
You know,
Time limit may be fixed.
The petitioners are accordingly directed to file necessary application before the tribunal within a period of 15 days from today with a copy of this order for doing the needful in terms of the same.
Highly obliged.
Similar order for 3 and 4.
No, this is on same one order. We have-
Same for the.
Therefore, we have not said respondent numbers here.
Public.
3 and 4. Dispose of
Lordship, the matter may be taken up at 2 o'clock. Lordship, Mr. Dinath is appearing. He is on legs in court number 1.
2 o'clock.
2 o'clock.
2 o'clock.
My lord. Subject is no further time. No. Ultimately, it's after starting time.
Let us see.
Lord.
Okay.
5, 6, 7 are connected. 5, 6, 7 connected. Okay.
Wait, please, Your Honor. Milord, road traffic accident, Milord, dated 17/9/2004. Records are there, Milord, in the second file, Milord. We have given a paper book, Milord.
You are the claimant.
I am for the claimant here.
What has happened?
Milord, death of one person, Milord, on 17/9/2004, Milord.
17.
9/2004 at 7:45 PM. 13th mile in Longphu, Milord, at 13 mile Longphu, Milord.
Then?
He was injured in the accident, Milord, shifted to GMC's hospital on 22nd/9/2004. He died, Milord. The GMC's hospital.
When did he die? 22nd?
22/9/2004, Milord.
Yes.
Now, the claimant, Milord, are the wife and 5 children, Milord, of the deceased, Milord. The mother of the deceased has been added as performer respondent, Milord. So in total, 7, Milord. If your lordship takes up the paper book that we have supplied, Milord.
Then what has happened?
Okay. Now, Milord, in this case, Milord, we have examined 4 witnesses, Milord. After the examination of the witnesses, Milord, the learned tribunal awarded a compensation of rupees 4,89,500.
4 lakh?
89,500. With interest at the rate of 6% from the date of the filing of the claim petition.
Yes, then?
We have filed this appeal, Milord, for enhancement on basically 3 grounds, Milord. First is, Milord, the date of birth was considered on the basis of the postmortem report, Milord, not on the basis of the school living certificate that we have annexed. Second, Milord, the income was taken as rupees 4,000 per month, whereas we have claimed income of 15,000 per month, Milord, and we have submitted documents, Milord, that we were running 2 electronic shops, Milord, to substantiate the maximum of income. The third,
Income was held as?
Lordship,
Income was held as 4,000.
4,000 per month, Milord.
As per you?
As per us, it is 15,000 per month, Milord.
Okay.
The third ground is rate of interest, my lord. We are paying for 12%, my lord, as in terms of the Workman Compensation Act, or 9%, my lord. That will come to later stage, my lord. Now, if you lord, in this case, my lord, we have examined 4 witnesses, my lord. The crux of the evidence that we have led, my lord, are only 4, my lord. One is, my lord, that the deceased was 34 years of age, my lord. The second is, my lord, that the deceased was running 2 shops, my lord. One at Nongpo, one where the accident took place, and one at Lalmati, Guwahati, my lord. Now, this fact, my lord, has not been disputed in cross-examination that he was running 2 shops, my lord. The third is, my lord, that deceased was maintaining a family of 8% dependency, my lord, including the deceased, my lord. 7 was a dependent, 8 including the deceased, there will be 8%. That is also not in dispute. And the monthly income of the deceased was 15,000. These are the crux of the evidence that we have led in the matter, my lord. Now, if your lordship takes up the paperwork for a moment,
Monthly income of?
15,000 we have asserted, my lord.
Yes.
If your lordship will take up the paperwork for a
Yes,
moment,
yes.
my lord. Page 1, my lord, is the claim petition, my lord.
Hmm.
If your lordship sees, my lord, 1 to 6, my lord, is the one is the wife, and 2 to 6 is the son and daughter, 1 son and 4 daughters, my lord. And in the next page, the performer respondent is the mother of the deceased, my lord. Page number 2, my lord. Now, if we take up the evidence of the claimant, my lord, it is certificate में बस नहीं आते हैं, it is certificate and जाते हैं. Now, if we take up the evidence of the claimant, which starts at page, my lord, 16, my lord, of the paper book. Page 16, page 16, my lord.
16.
Lordship. This is the evidence of the claimant, my lord. Now, first page and second page only we have stated that there was a road traffic accident and in which we died, my lord. Now, road traffic accident, the injuries, the death, my lord, and the liability of the insurance company are not in dispute, my lord. So we are not going on that, my lord. Lordship may come to page 17, last paragraph, my lord. The income and the page, my lord. Page 17, my lord.
CW1 is the wife.
The PW1 is the wife, CW1. That's why page 17, my lord.
Yes.
Last paragraph, my lord. That I stated my husband Ram Prasad was the only earning member with the family. I further stated that 7 except his earning or any member of our family has no earning of their own during the lifetime of his husband, and we are capable of we are not are capable of earning any money even today. After his death, the whole of the business collapsed, and today we are virtually without any prop. Once an affluent and happy family has been totally reduced to pauperism. That I next page, you know, that I stated my late husband was a healthy man of about 31 years, 34 years of age, having good physique and was suffering from no ailment at the time of the accident. He had good knowledge of electronic goods. He run 2 shops of electronic goods, one at Lalmati, Guwahati, and another at 13 miles so and so, Meghalaya. He dealt in electronic goods and specifically used to repair goods like radio, TV, VCRs in his shop. In that business, he has engaged employees in his shop on monthly wage basis, and he himself looked after the business. A successful businessman, that is not relevant, Milord. Now, paragraph 11, last paragraph, if I may read, Milord. That I stated this husband was maintaining the family very successfully, incurring all the expenses upon me, his children, including the expenses of their school and private tuition, medication, treatment, and he was equally careful about his old and ailing mother. My husband earned a good reputation in the society. He was a loving husband, a loving father, an obedient son, and come to a conscious citizen love. Now, I have exhibited, Milord, 35 lakhs I have demanded. I have exhibited 5 documents: accident information report, postmortem report, FIR charge sheet, and school living certificate. If your lordship takes up the postmortem report for a moment, page 21.
Yes.
The first very column, Sri Ram Prasad, male, 45 years, Milord. If your lordship sees, Milord. Very top hand, right, left side, Milord. Age is mentioned, Milord, 45 years. Page 21.
Where is it?
Milord, for very top, Milord. Age Ram Prasad, 45 years, my lord. This is the birth certificate, school living certificate, my lord. Page 21, my lord. Postmortem, I am here.
Case 21.
That's it. In the left side, my lord,
Name, sex, age and so and so.
lordship,
Ram Prasad.
45 years.
Correct.
Now, if your lordship now take up, my lord, the
What is the original of this certificate,
my lord,
of this transfer certificate?
my lord, this is the my lord, page 29. This is the school living certificate, my lord. Page 29,
You had produced that,
lordship.
did you exhibit
That
that?
I have exhibit 5, my lord.
Page 29.
Page 29, my lord. Now, in this page 29, lordship can see this translation of column number 7, my lord. Date of birth was 15/12/1970, my lord. Anyway, if we go by this date of birth, my lord, the age would be 34 years. Now, the question that comes up, my lord, is whether the postmortem report or the school living certificate has to be taken into consideration while determining the, my lord, date of birth. That is the first question, my lord, in this matter. Now, cross-examination at page 30, my lord, of the claimant, my lord.
Yes.
My name is Durgavati Devi. At about 7:40 p.m. on 17/9/2004, my husband Ramprasad met with a motor accident at 13 Mile area at Guwahati and sustained injury. He succumbed to his injuries on 22/9/2004. I have claimed compensation of 35 lakh, my lord. He was again re-examined, my lord, and that lordship will find it page 32.
Yes.
Page 32, my lord. I have filed this cause along my daughters. The present age of my elder daughter is 19 years. Present age, my lord, 2009, my lord. It's wrongly typed as 2004 years. In the postmortem report, the age of my husband is mentioned as 45 years. It is not true that I have not furnished school living certificate. I have not furnished school living certificate exhibit 5. Exhibit 5 is under objection. It is not a fact that my age that I have stated is false. My husband is a shopkeeper. It is not a fact that in the exhibit 5 is not correct. It is not a fact that my husband was not injured in the accident. It is not a fact that he was not injured in the accident with Tata Sumo. It is not a fact that I have made a false column. Now, PW2, my lord.
Just PW.
PW2, page 34, my lord. He is the eldest brother of the deceased, my lord. Only paragraph 2 and 3 we will read, my lord, in the matter. Paragraph 2 states, my lord, that at the time of the accident, this is Ramprasad, 34 years of age and resident of so and so. The
34 is
That's it.
chief of exam.
Chief examination chief of Shiv Kumar, the eldest brother, my lord, of the deceased.
PW2,
PW2, my lord.
elder brother.
Eldest, my lord.
Yes.
Paragraph 2, my lord.
Hmm.
That I stated at the time of the accident, the deceased Ramprasad was 34 years old and a resident of Dhirenpara, Guwahati. The claimant, who had a wife and children of the deceased, were fully dependent upon the deceased during his lifetime. The deceased was the only earning member of his family, consisting of his wife, claimant number, his 5 children, claimant number 2 to 6, and the performer party, Sri Ganga Devi, who is the mother of the deceased. the mother-in-law of the claimant number 1 and the grandmother of the claimant number 236. The claimant number 236 are minor and being represented by the mother natural guardian, Sri Durgavati Devi. The claimant number 1 hereof. That I state that after the death of the deceased Ramprasad, his mother Sri Ganga Devi has given consent to the claimant number 1, Sri Durga Devi, filing the claim petition. Milord. In paragraph 4, that I state that this is Ramprasad was successful businessman, he acknowledged mechanic repute in
He
electronic
had
book.
5 children.
5 children. Milord. 5 children, 1 mother, total number of wife, total number of,
At what age did you get married?
Milord, very young, Milord, 18, 19 years, Milord.
You were 34.
I was 34 at the time of the
The
accident.
deceased was 34. He already had 5 children.
All of it. Naturally, marriage was solemnized very early, Milord. I also don't have much instruction on the matter.
And your wife at that time was 33.
33 years.
Okay, then
Now, Milord, this witness has only stated, Milord, that
what was the age of your children?
Milord, that we have mentioned, the eldest daughter was 15 years of age when I died, Milord.
15.
15, Milord.
Then you married at what? 17.
Like that only, Milord. Earlier, Milord, was like that only, Milord.
Earlier, this is of ancient age or what?
Milord, Milord, if 70s, Milord, I am thinking 78, 79, Milord.
What's 78?
You were born in 1970, Milord.
Yes, born in 70.
Milord.
So marriage was when?
The boy after, it has to be 85, 86, Milord.
15 years he got married.
15, 16 years, Milord. Earlier, Milord, in that way only marriage was being solemnized, Milord.
Very doubtful.
I leave that to your lordship discretion, Milord.
No, had it been something unreasonable, friend, but these questions will definitely crop up.
Lordship has seen, Milord, here also,
The
Milord.
entire objective is you should get the compensation to be just and proper.
Lord,
It cannot be a windfall.
cannot be, Milord. I leave it to your lordship discretion, but lordship has seen, Milord, in the Child Marriage Act recently, Milord, how many persons have
No, we
got
are not
arrested?
going to the illegality, but
Yes, Milord.
is it?
No, child marriage was already a ritual, Milord. That marriage, his wife, Milord,
We are
basically
not talking about some ancient period. This marriage had taken place in 87, 88,
87.
not in the 19th century,
Lord.
1920, 1930.
Now also, Milord, if we have cases that we have found, Milord, after this new act, Milord, we have cases found 14, 15 years person getting married, Milord. The girl, Milord. I leave that to your lordship discretion. I will not on that, Milord. There is concrete evidence, Milord, on record to show that he was 34 years old at the time. And if your lordship sees the evidence, the age of the children, Milord, there is no contradiction at all, Milord. And on this point, Milord, that the lordship has raised, that was never asked in cross-examination by the claimant, Milord. Or any
No,
other.
it's our duty to see whether the.
Lordship, yes, Milord. But Lordship, we cannot
just
at
and
this
proper
appellate stage,
reasonable.
Milord, it will be difficult for us to travel beyond the record, Milord. At this stage, Milord. My humble submission is that. This is the
The
period,
other, your contention is regarding the,
Milord, regarding the
income.
fixation of income, Milord.
you say that you had 2 electronic shops
I have to enable
and the income has been fixed at 4,000,
4,000.
which according to you should be 15,000 per month.
15,000.
15,000 per month would be how much? Did you pay income tax?
No, Milord.
Were you,
Five.
are you an assistant under the income tax?
No, Milord. Income tax is not required, Milord, for Milord termination of income. That will come to that, Milord.
So
There-
if he's earning, his slab is more than
Yes,
the
Milord.
minimum slab.
Suppose when someone is,
It may not be required. You may say that I did not file, but if you file it, it is easier for you to
yes,
say.
Milord, that it will be more
Then
easier
how
for
do
us.
you prove?
Milord, that
15,000?
will come to that, Milord. How we are, basically, my basic and proof, Milord, in this case is that I am maintaining 8%, Milord. 4,000, Milord, is almost impossible. At least, Milord, lordship has to give them, Milord, basically food, clothes, and shelter, Milord. This is life. Life is not an animal existence. So education and health will also come over, Milord.
You are going to, you're digressing the issue.
Milord,
You're not, you're digressing the issue. You're not on that.
No,
People may live with
lordship-
1,000 also.
Milord,
on
it's
the
almost
footpath,
impossible. How can
Are
I,
we able to help them? We are not being able to help them
Milord,
in spite of the constitutional
whether-
mandate.
We'll come to that, there are case laws on that
No,
basis.
we cannot, you cannot digress the issue that whether
Sir.
4,000 would be enough to feed a family of 7.
That's it.
It's up to, but we are here only to determine whether the assessment was done reasonably, fairly, transparently.
That's it. That much.
That is the only
That is the only thing, my lord.
outlook we have.
Now, they have not come for an appeal, my lord. The findings of the tribunal has also attained finality, my lord, so far as they are concerned. Now, what my case is, my lord, that the tribunal has also hold that the shop was there, my lord. Now, that if you lordship see the finding of the tribunal said that he could not have earned less than that. Now, MBA 160 says, it says, my lord, the compensation has to be just, my lord. It cannot be that the bare minimum it has to be this, then we will fix that only, my lord. We'll come to all the aspects, my lord. There's 4 evidence and only 4 aspects are there in the evidence, my lord.
Your wife,
My lord.
the wife of the deceased,
Lordship,
then the elder brother of the deceased.
lordship.
Who else? 2
One employer, my lord, PW3.
employee.
Yes, my lord. 2 employees were there. One was my youngest brother was also employed and he was my brother. He's PW4.
He was working with you.
He was working with me, my lord. And one employee is there. He's PW3, my lord.
Let us see their person.
Lordship.
Shiv Chandra is your elder brother.
Yes, my lord. Shiv Chandra is my elder brother. That's okay. Bible. Now, PW3 is a page, cross-examination will go, only one line of cross-examination was there. It is not a fact that in respect of my brother, age and income, I have given false evidence. Page 37. my lord. Now, page 39, my lord, is the evidence of PW3, the employer, my lord.
30.
Page 39, my lord. The 2 page only, my lord. First page, I know the claimant. She is the wife of Ram Prasad who died in an accident, so and so, so and so. 5 children, my lord, and wife. The deceased Ram Prasad was my employee. I used to work in his shop located Lalmati, Guwahati.
He was
under
an employee, he was the, who was
Employee.
his employee?
My lord, the deceased Ram Prasad was it should be employer, my lord.
Was my employee or
Employer. I used to, next line makes it very clear. I used to work in his shop located in Lalmati, my lord. I used to work in his shop located in Lalmati, Guwahati under the name and style of Atul Electronics on the monthly wage basis of rupees 5,000 per month. He has also stated there was another employee, paragraph 3, who was getting 7,000, my lord.
He is your brother.
He is not my brother, my lord. Ram Bhajan Sharma is not my brother, my lord.
With 5,000.
Yes, 5,000.
wait.
my lord. And my lord, the other one is getting, when I page 3, paragraph 3, my lord, that another employee was there. He was my brother. He was getting 7,000. my lord. That only, my lord, evidence is there.
Pay
Paragraph 3, my lord, same page 39.
another employee.
Another employee, my brother.
No, that is his statement made by somebody.
Now, in cross examination is at page, my lord, 41.
Yes.
At present, I don't work for job. I work for with Ram Prasad till December 2003. He owned a shop. Even though I was an employee, I was not offered any paper against it. It is not a fact that I have given false evidence and that I was not employee of Ram Prasad. I know that the income of Ram Prasad is 15,000. In the affidavit, I mentioned that I have heard about his income. It is not a fact that I mentioned his monthly income is learning from others and I have no knowledge. It is not a fact that I have given false evidence for the benefit of the claimant.
But he left the job in December 2003
Lordship.
and the accident was of September 2004.
4.
Almost a year back.
Almost a year. Now, Lordship, the only factor, my lord, that I will insist on that he was running 2 shops, my lord, is not in dispute by the cross examination also by the opposite party, my lord. Now,
No, here, this employee, he
Yep.
was working where?
he was working at Guwahati, Lal
And the other one?
both were employees, were working together in different shops. One
No,
shop
no,
was
where is the,
that's it. PW4, it comes to, it pays for.
who was working there?
Both the employees were working in both the shops,
No, he has not said.
depending on the nature of work.
Did he say, did CWP say something,
He
anything
was,
about
he
this?
said that he was his employee, and he was running.
Where?
First thing, PW3 has stated,
No,
that,
in PW, at page 39,
yes, Lord.
paragraph 1, he says that he was working at a shop at
Lal
Lalmati.
Guwahati under name is
He
Arjun,
has not said it about any other shop.
any other, he is not.
Where does the other shop come from? Who has said?
PW1 and 2 has said,
One has the, it's a big thing.
he got 7,000.
39, you have produced an employee, that's okay, fine.
I worked.
But this employee was of the shop at Guwahati.
Yes, this shop is at Guwahati.
And what about the other employee? Has he said something about the shop? What is he paid? Forty-three.
43. Now, he's a brother, and employee, I know the claimant. The claimant number 1 was the wife of the deceased Ram Prasad, who was my own elder brother who died in an accident so and so at Guwahati Medical College. The accident took place so and so 13 mile police outpost Meghalaya by offending vehicle number so and so in front of. Accident took place so and so in front of the shop establishment of the deceased at 13 mile Burning Heart. The claimant number 2 to 6 are the children of the deceased Ram Prasad. That I stated the electronic shop, that this is Ram Prasad was a successful business. He is acknowledged mechanic of electronic, or he also owned and possessed 2 shops, one at Lalmati, Guwahati, and another at 13 mile Burning Heart. Meghalaya, where the business of selling electronic goods and repairing of electronic goods at radio, TV, VCR was carried out. I put my service as an employee at the shop situated at Lalmati, Guwahati. Under the name and style of Atul Electronics beside me, there was another employee in the shop who used to repair the work at a monthly salary of 5,000. I used to look after the business at Lalmati, Guwahati, for which I got monthly of 7,000 only. My deceased brother, Ram Prasad, occasionally used to visit the shop to take into the account of the business at Lalmati. He stated the monthly income, now page 45,
Page?
45,
Yes.
the exhibit, First, the registration certificate of trade license, exhibit 7. Thereafter, these are, basically fixed money deposit receipts, in the savings account, my small savings, from 8 to 15, Now, if the lordship takes up there are 2 income certificate also that was exhibited, exhibit 6 and 6.1, that is mentioned at, page 3, 15,000 per next year with, and marked as exhibit 6, and page 48 is the certificate, Page 47, is the certificate. Lordship has page 47. It is a certified that Ram Prasad, son of so and so. It is certificate from Burning Heart, Dhirenpara PS Patasal Guwahati in the district of Kamil was successful, who was running 2 shops of electronic affair at Lalmati, Guwahati, and a 13 mile under Burning Heart police outpost during his lifetime. From operating his shop, he had employed some employees also. To the best of my knowledge, his business was running in good condition, and he was dealing with customers. Was it good? His monthly income was definitely more than rupees 15,000. Now, this is also a certificate from here, page 48. I certify that I know late Ram Prasad, son of late so and so, participated in the district of Kamrup, Assam. He had two shops of electronic good in which he did repairing work. His shop were located at Lalmati and at 13 Mile at Bernihat Police Outpost, Meghalaya. I had occasion of visiting his shops. He had employed some employees for
But
running his
this,
shop.
claim is of the year 2004.
Lot-
This certificate is of the year 2008.
Lordship, it is for the filing of the evidence only we have procured this certificate.
After 4 years, he gives the certificate.
Because that was, certificate was needed only at the time of
You
filing
could
of,
have produced, you could have.
when the evidence was required.
You could
Lord.
have adduced his evidence directly that yes, I know. But did he come?
No, my lord, he has not.
And then prove
No, my lord, he has not prepared.
the certificate is not immediately given.
Lordship, that is a fact, that is there in the certificate, so we are not disputing that. Lord.
This is
Now,
certificate lump sum
Page 49, my lord.
was running into shop located at Almaty, Guwahati, and attachment of Bonihar. How did you know about the Lalmati shop?
Lordship,
He is a person from Bonihar.
Lord,
He is the headman.
is the headman. He must be knowing, my lord, headman normally knows about every person, my lord.
You should have produced him. They would have got.
They
a
should have
transfer.
come and deposited.
Because
It is
when
both
did-
times. It would have
when
been,
When did he join as the headman?
yes, my lord,
How does he know
how does it?
a resident of Dhirenpara?
It would have been more concrete, my lord, if we could have produced him as evidence. My lord. That is a fact. No, we are not disputing that. My lord. Page 49 is a trade license. My lord.
What is 48?
48 is again a certificate, my lord, that you are running it to stock. My lord.
By whom?
My lord, this is by, my lord, Hindustani Sammilan, my lord. Fancy with that. Lord.
I said to Ram, he had two shops. His shops are located at Almaty, Guwahati. At the option of he was also not produced.
Yes, also not. Now, page 49, my lord, is the trade license, my lord.
Exhibited.
Yes, my lord, exhibit. It is exhibit number, next page is the exhibit, my lord. Fifth type T. It is exhibit number, my lord. The first exhibit, my lord, at page. This will be exhibit number 7, my lord. 6 and 6(1) was the income certificate, 7 is the trade license, my lord. Now, this trade license, if your lordship says, my lord, that it was valid only till 1991, my lord, 33, 1991, my lord. Now, page 52, lordship comes
Just
up.
a minute. What is this 34 here? Khan 34,
Page number, my lord.
50. Your 50. There cannot be any resident.
No, it said, my lord, basically the license was awarded Ram Prasad so and so, 34 to carry out.
What is this 34? 34 perhaps is
Result
the age.
34. Not age, my lord.
And see, this was issued in the year 1987. You were not even 17 at that time.
Lordship.
Not have been done.
Right.
Your age was 34 at that time.
My lord, 34, my lord, just age is not mentioned, my lord.
This 34 is the age they have mentioned because this is
Resident of 34, my lord.
cannot
Place,
be
my lord.
resident of 34. Why they have written 34?
Not
The place is for the to write the residential address.
resident, my lord, to, like, how can it come with age, my lord? It cannot come to age, my lord.
Then what is 34? Tell us.
Lordship. That, my lord, my maybe 91, I am 34, my lord, and 2004, I will be 50, my lord. So this is the trade license, basically, my lord. It is, it was up to 91, my lord. It was obtained in 87, my lord. Yes, my lord. Yes, yes, sir. Stan, my lord, it's written as Stan only. Resident should come, my lord.
The man is the space is meant for writing the residential address,
Yes, my
but
lord. It cannot be age,
the-
my lord. The house number or something would be like that. my lord. Now, we did,
on age, perhaps you should not put too much of emphasis. Come to page for 52.
yes, my lord, page
52.
52.
Your age at 1999 was 40. Declared age
Lordship, 1990.
1999.
No, where, my lord, lordship? Lordship, I don't know, my lord. Let us come with the record, my lord. Let my
No,
learned friend
it's
submit, my lord.
your policy,
Lordship.
fearless policy.
And fearless for the page 52, my lord.
Page 52.
Yes, my lord. This is not mentioned as age, my lord.
This is age after Ram Prasad.
Only
so
40 is written, my lord.
40 is the age. We know something about this kind of receipt.
Lordship. Lordship. So putting it, my lord, in such way, my lord, when there is a school living certificate, we come to that, my lord. Let us be, my lord. What I want to emphasize on this receipt, my lord, only, my lord, to that extent, my lord. First is, my lord,
You should not have given this receipt. Who asked?
no,
you?
my lord, we are trying to be fair only, my lord.
If
Let
you are
come-
being fair, you
Lordship.
should not have given this receipt.
If your lordship says two things in this receipt, my lord. One is, my lord, 30, my address is shown as Atul Electronics, village so and so, my lord. The address part, my lord, in the 40 place, my lord. Now, I have deposited some 250 to 50 amount per minute. The interest that I am getting, my lord, for this is 10% PA compounded annually. Just after the name of my nominee, my lord.
Yes, Mr.
My lord, let me complete with the 2 or 3 aspects, my lord, that are left, my lord.
I have understood your case.
Lordship, some is there, my lord.
Something else may come out again.
Yes, Lord, let us, my lord. Yeah. Now, if your
Better
lordship,
to stop here and
the lordship may take up the judgment, my lord, last page only, one paragraph, we will go. Well, 3-4 case law that will put up, my lord. We will
Okay.
my lord. Last paragraph only we are reading, my lord. Page 64, if you lord.
Page?
Page 64, my lord.
Yes.
In the instant case claimant Durgavati Devi, the PW1 stated that her deceased husband was running two shops and his monthly income was rupees 15,000 per month. PW2 and 3 in their evidence also stated the income of the deceased, and as per their version, the income of the deceased was 15,000 per month. The PW4 has exhibited two numbers of income certificate, Exhibit 6 and Exhibit 3A, but the person who has issued the said certificate was not examined by the claimant side to prove the same. No any books of account of the business of the deceased was produced by the claimant side to show the actual income of the deceased. Though the witness have stated that the deceased had running two shops, but the claimant side has stated that the produced only one document in respect of one shop situated at Guwahati, that is Exhibit 7, the trade license. From the evidence, it appears that the business of the deceased was repairing of electronic items, and so and so selling of electronic goods, and selling of electronic goods. Nowadays, such a pretty businessman can earn at least 4,000 per month. So under such circumstances, in the absence of any documentary evidence regarding the income of the deceased for the purpose of compensation, computation of compensation, the income of the deceased can be reasonably fixed at 4,000. That the income of the deceased was 48,000 per annum, deduction 1/3 of his income, personal expenses, loss of annual so and so 32,000. Though the PW1 exhibited one school transfer certificate to prove the age of the deceased, but from the post-mortem report, it appears that the age of the deceased was 45 years. From the cross-examination of PW1, it appears that the age of her elder daughter was 15 years and she was 33 years of age at the time of the accident. So under such circumstances, the age of the deceased can be considered in the age group of 40 to 45 years for the purpose of computation of the compensation, and as such, the appropriate multiplier would be 40/15. This is the conclusion, Milord. Now, Lord, the factor, Milord, whether the date of birth should be based on, Milord, the school leaving certificate or the post-mortem report, Milord. The Lordship, that question has been raised, Milord, never raised in cross-examination. So whether that questions could have been taken into account by the
This
appellate.
postmortem age
Milord,
may not prevail upon a date of birth. You may be correct,
Lordship.
but postmortem age is normally given by the persons who accompany the
All the
deceased or by their own assessment.
Right.
But here we have a certificate of the peerless which says that in 1999 you were 40, and therefore this age which has been given in the postmortem appears to be commensurate with that declaration.
There are two difficulties on that, Milord. One is, Milord, that question was never put in cross-examination.
Now, was this person who had issued the certificate regarding the age, was he produced as a witness?
No, Milord.
Since this has attained a very crucial
Lord.
point.
No, I will leave it to your Lordship discussion on that, Milord.
Normally, if the claim is a reasonable one, claim not the amount, claim the constituents on which the claim is based, like the age
Right.
or the income, family members. If those are reasonable in nature, then we should not be hyper-technical. You call the
No,
doctor, you
correct.
call this. But here there are inconsistencies which are apparent on the face of
No.
it. Under those circumstances,
That is my
it
submission.
was incumbent upon you to produce
Yes,
that
Milord, correct. Milord.
headmaster. Or
That
the-
is my specific submission, Milord. If they would have put these questions in cross-examination, Milord, I would have produced the headmaster at that point of time, Milord. But at this, after 20 years, Milord, if I am sent back to that stage, Milord,
But how do you overcome the age which has been given in the pure document, peer list?
Milord, first thing, Milord, whether
The peer document.
that is the age that it
Age
means.
is
Whether-
even not reasonably coming out with the age of your number of children, the age of your eldest
Lordship.
eldest child.
Right.
Daughter,
15
son,
years,
daughter, 15. And your wife,
Milord, if I even Milord, if I get married at 25, Lordship, or
you have a license at 17 years of age.
Lordship,
It is not
16 was
possible.
at that point of time, Milord, working age was 16, Milord. at
No,
that
no,
point.
17, you have a trade license at
Yes,
17 years.
Normally. See, Lordship, let us not go on then age perspective. Lordship is so convinced, Milord. But on,
Age, perhaps you may not have a case. On the income, you
Lordship, now the income part only, then Milord, we will on assert on that, Milord, for the income part. We have given certain judgment, Milord, on that, Milord.
income you may have a case.
Lord. Income लिखा है फिर अपने ना. Now, Milord, if the first judgment, Milord, is of 1998, yeah, it's Milord, Allahabad High Court, Milord, and I will take a Lordship to page paragraph 4, Milord. On a careful consideration of the married, Milord. Ramesh versus Rajampal, Milord, Raja Rampal.
Rajamal.
Rajamal. Paragraph 4, my lord.
How do you, what is AIHR?
That's it. Just one
Now, what is the citation?
citation in 1998 EIHC 4476.
What is
my lord.
AIHC?
It's not, it is EIR manual, my lord. License,
No, no.
EIR online, my lord. And EIHC should be Allahabad High Court, my lord.
No, this is Madras High Court, you have said.
Madras, it is Madras High Court, my lord. Yes, Madras High Court, my lord.
We haven't seen such a citation. AIHC.
Lord. It was taken printed from EIR online, my lord.
There would be some other,
There may be, my lord. We will provide the
Oh,
assistance citation on also. my
this
lord.
is Madras.
Madras High Court, my lord.
Ramesh.
Ramesh versus Rajamal.
Rajamal. Yes, para.
Paragraph 4, my lord. On a careful consideration of the contention of the learned counsel for the appellant, it could be seen that almost 70 to 80% of the accident cases, the claimant are not able to produce any evidence with regard to the income of the deceased. Only in case of employed person, we can accept the salary certificate, or in some cases, other cases, if he is an income tax assessee, we can accept some evidence with regard to the income of the deceased. If a person who dies in the accident is self-employed and not an assessee in those cases, the tribunal as well as the High Court has to proceed to find out the income of the deceased on the basis of the nature of the employment of the deceased. In this case, the deceased was been selling raffle ticket on a hypothesis that tribunal seeks the income of so and so. So more than 70 to 80% of the cases, my lord, income proof is not there. my lord. Now the second one is, my lord, Delhi High Court.
Delhi High.
Page 3, my lord.
2016.
Yes, my lord. 2016 SSC online, Delhi 290, my lord.
Royal Sundar.
That's it. Well, sir. Paragraph 5, page 3.
Page 3.
Page 3, paragraph 5. I agree with the submission of the learned counsel appearing on their behalf that there cannot be a thumb rule that in all cases where strict proof of income is not forthcoming, the tribunal or the High Court will be left with no option but to go by the minimum wages prevailing at the relevant point of time. The fact and circumstances brought out would be seen in its entirety. It has been proved on record that the family of the deceased, including the widow and 6 minor children, besides 4 daughters already married and settled in their respective matrimonial homes. The evidence also clearly showed that the deceased was concerned about the proper settlement of their children in the appropriate avocation with which objective he had arranged for the proper education in various institutes. Thus, he is shown to have been investing in their education by arranging for payment of the requisite fee to repay the expenses incurred towards such pursuit of the deceased. Also reflected that the earning would have been coming his way as a self-employed die maker and could not possibly be so low at the level of minimum wages.
This will be on the facts of the case.
Lots it. Now, SSC, Supreme Court 2022 SSC online, Supreme Court 1699, Lord. Rajavati case, Lord. That is page 6, Lord, paragraph 21, Lord. 19, 20, and 21 we can read, Lord. Let's page paragraph 21, page 6, Lord.
Yes.
We'll go with paragraph 21 first, Lord. In view of the above, we do not agree with the view taken by the High Court while rejecting the salary certificate exhibit 19 and payslip exhibit 20 of the deceased merely on the ground that the person issuing the two aforementioned document was not examined before the learned tribunal. The said document are conclusive proof of the income of the deceased and was also corroborated by the statement of the deceased wife, appellant number 1, and his co-workers. As such, the High Court was not justified in assessing the income of the deceased as so and so per month on the basis of the minimum wages fixed by the state at the relevant time. Resultantly, we affirm the finding of the learned tribunal as far as relate to assessing the deceased income at so and so, 11,000 something. Now paragraph 19 and 20 says that basically Motor Vehicle Act is a beneficial legislation. Strict proofs of evidence would not be called for in the matter. Now similarly, the next judgment is of Delhi High Court. It is a very 3-paragraph judgment only. Paragraph 2, if your lordship takes up.
New India.
New India, 2010 SSC Online, Delhi 1752. It is a settled law that motor accident claim
Paragraph?
tribunal, paragraph 2,
The name New India. There are two.
paragraph 2. May I read,
Yes.
It is a settled law that motor accident claim tribunal has to conduct an inquiry for the grant of compensation. The inquiry has to be conducted in respect of all aspects involved in the compensation case, including the aspect of employee of the deceased. There is no doubt that in case of business person or self-employed person, the books of account are the best evidence. And if the books of account are produced, then there is no need to further evidence for proving the income, and the tribunal can infer income from the books of account. However, when a person indulges in a small business or is a self-employed person and the family is not involved in his business activity and is not aware about his business activity, the family can prove the income of the deceased by indirect evidence. In the present case, it is not disputed that the deceased was the sole earning member of the family. The family was living in a rented accommodation. The two of the claimant children of the deceased were studying. The deceased had also employed a domestic husband and driver. The family proved the monthly income of the deceased by placing on record the rent receipt, school fees receipt, and payment made to maid and driver and other expenses. The rent itself was 5,000. The children were studying in group so and so school and were also taking tuition. The deceased was also the owner of a truck bearing number so and so. He was also having a permit of the truck. He was paying salary to the truck driver. He was in the business of removal of debris and the supply of material. His bank statement was placed on record to prove the receipt of disbursement. From all these document and expenditure proved on record, the tribunal can come to the conclusion that this must be earning rupees 25,000 per month. However, the tribunal considers the decree was a taxable income, and the family of the deceased was not aware of the fact whether he was paying income tax, and the tribunal deducted the tax of this account. So overall,
I consider that there was no information.
tribunal awarded 25,000. New India preferred an appeal. The Delhi High Court have ruled that there was no information. Now, now, Lordship, in this case, Lord, the fact is that I'm maintaining a person, family of 8 persons, Lord, including myself, Lord. Pay deposit is a peerless receipt, Lord, so that I'm making some deposit also for the welfare of my child, Lord. So in such circumstances, Lord, whether the tribunal was right, Lord, in considering, and if your Lordship has seen the judgment of the tribunal, Lord, it says, Lord, basically that the fact that I was running through soft, Lord, is not in dispute. So whether in such circumstances, Lord, the tribunal was right to consider my income as 4,000, and the finding Lordship has seen the tribunal would not have been less than that, Lord. That is my first contention in the matter, Lord. Now, there is a one chart, Lord. Just give me 1 minute, Lord. How much money if we require, my lord, for a family person to run, my lord, the basic necessities, my lord, of a family person, my lord. If your lordship can take up this, my lord, for a moment. Now, this, we have prepared a chart, my lord, quantity for 7 persons, my lord. In this, my lord, if the lordship takes up this, my lord, at that point of time, my lord, it will come to at least, my lord, 12,000 rupees, my lord. To that extent, my lord. And
They were vegetarian.
lordship,
The family was a vegetarian family. Why we put fish and egg and meat?
lordship, lordship may deduct that, my lord, and add some more milk to it, my lord. So at least, my lord, that has to come, and lordship, at least when I'm
You have not put tomato here.
lordship,
You have put
at that
tomato.
point, it may not have been
It is
that costly, lord,
Escalated.
in the matter, my lord. But that is my submission, that directive principle said, my lord, that states should endeavor, my lord, to give at least the basic necessities, my lord. Basic necessities has been implied, my lord, even education and medical expenses, my lord. So whether in such circumstances, 4,000, I can maintain that family, my lord, with the medical receipts also that we have annexed, my lord, in the case, my lord. That is one, my lord. Now, lordship, the second submission is with regard to the fixation of rate of interest, my lord. We supplied the judgment, rate of interest. My lord, basic, the
This is date of birth,
my lord, interest, my lord.
rate of interest. For green fund.
Now, my lord, 171, my lord, basically section 171 of the MBA does not say that rate of interest should be such and such. It should be that it should not be earlier than from the date of the filing of the claim petition, my lord. And if your lordship says, my lord, there are other acts, my lord, like the Workmen Compensation Act, the Consumer Protection Act, and the Arbitration Act, my lord.
But
Every
rates have been specified.
lordship, provision,
But rates have been specified.
rate has been specified. Now, what is the difference? My first question to my learned friend would be, what is the difference between a, my lord, Workman Compensation Act and, my lord, the Motor Vehicle Act? Because in both the cases, a person suffered injuries, my lord, for which to pay compensation, my lord. Even in lot and, my lord.
Yes.
My lord, we start with, my lord, Amresh Kumari judgment, my lord, Supreme Court decision, page 2, my lord. The question, page 2, my lord.
This was from the date of filing and not.
Yes,
the
my lord,
date
this
of
is from the date of filing. Now, second judgment is, my lord, 9%, my lord. Even the Guwahati High Court has said it should be 9%, my lord. Then there is judgment of Honorable Mr. Justice Devashish Borua, my lord. He has make out a case, my lord, under which check what compensation is granted, my lord. And in that case, my lord, if your lordship will pick up the case of that case, my lord, if the fourth judgment, if your lordship takes up, my lord, directly.
Name.
My lord, New India Insurance Company, my lord, versus Lata Agarwal, lord. Page number. Page number, my lord, 7, paragraph 17, my lord. Married, my lord.
Yes.
Okay.
Yes.
Grant, paragraph 17, my lord, the grant of interest is in bold, if your lordship is, my lord.
17.
Page, paragraph 17, page 7, my lord. Paragraph 17.
Yes.
Grant of interest, my lord. 59, my lord. Section 171 of 1988 Act deals with the award of interest where the claim is allowed. It reads as follows.
This is quotation from Putama.
Lordship, yes, my lord. Yes, my lord.
Yes.
Award of interest where the claim is allowed, whether any claim or tribunal allows a claim for compensation made under this act, such tribunal may direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier from the date of making the claim, as it may specify in this behalf. Under the said provision, no rate of interest has been fixed, and its duty is bestowed upon the tribunal to fix the rate of interest. The rate of interest as provided and granted under different act is as under. Section 4(3) of the Workmen Compensation Act provides payment of interest at the rate of 12% per annum. Here now 2022, Justice Chandrachud had held, my lord, that it should be from the date of accident, my lord. That judgment we have annexed here, my lord, in the Workmen Compensation Act. Interest 12% per annum or at such higher rate not exceeding the minimum of the lending rate of the scheduled bank for a delayed payment. The Consumer Protection Act, even though provides no provision for the grant of interest, this court has granted interest by invoking section 3 of the Interest Act and section 34 of the CPC has awarded interest rate at 12 to 18% for delayed payment. The Land Acquisition Act will provide interest for the delayed payment of 9% for the first year and 15% for the rest of the year. Arbitration and Concession Act provide interest at the rate of 18% per annum.
Here 6% has been granted.
Yes, 6% has been granted, my lord. And the earlier judgment that we have referred to, my lord, the Supreme Court has said 6% is bad in law. Therefore, the Guwahati, this question was also raised before the Guwahati High Court, my lord. Justice Mir Alfaz Ali had that in view of the Upahar Tragedy, my lord, that case, my lord, it should be 9%. That both the judgments are here, lord.
Okay, we'll come back.
Minimum 9%, my lord. That paragraph is at page.
Which one?
Second judgment, my lord. It's Manu ST 0845 2013, my lord.
Santhilata.
That's it?
Santhilata. What's the
No,
name?
no, no. That is, my lord, that judgment is different, my lord. We'll come to that, my lord. That is basically, my lord, it says
No,
that
no,
one
no, you have received
second judgment from in the paper book that we are submitting, my lord.
second.
Second, my lord.
Those pin.
Jaspin James, yes, my lord, Jaspin James. Page 8, my lord, if you love it.
Paragraph.
Paragraph 19, page 8, my lord. Further, the award.
Just a minute. Paragraph.
Paragraph 19, my lord.
Yes.
Page 8, sir. Further, the
Yes.
award of interest at the rate of 6% per annum on the compensation has been awarded both by the tribunal and the High Court is also bad in law. For a reason that in the case of so and so, this court awarded interest at the rate of 9% per annum on the compensation awarded in favor of the appellant. There is no justification for them in not applying the ratio of the above mentioned case. the fact situation of the present case. We therefore grant interest at the rate of 9%. Now, this judgment was considered, my lord, by the Guwahati High Court, my lord.
Yes.
Now, in the Guwahati High Court, 2017 SSC online, 740 million in Pushpa Maheshwari case, my lord, page 6, my lord. I'm sorry, page 7, my lord. We're just reading the mark portion. Paragraph 10. Page- Paragraph 17, my lord. Page 6, relevant portion is page 7, my lord. Start from page 6, my lord.
The tribunal.
Lord, the tribunal. Lord, relevant is Lord from Lord, page 7, Lord. Next.
Yes.
Page 7, Lordship is Lord.
Hmm.
Further, interest at the rate of 6% per annum on the compensation was awarded by the tribunal, which was enhanced to 7.5% by the court. The interest is determined by both the court below Barin law as per a legal principle laid down in so and so, wherein this court has awarded interest at the rate of 9% per annum on the compensation awarded in favor of the applicant. Applying the same legal principle, we grant interest at the rate of 9% per annum, following the said principle, interest is enhanced.
But how do you criticize this judgment, which was rendered in the year 2009, and Upahar Cinema came much later?
2012, my lord.
Yes, this award is of the year 2009.
2004, my lord, when the accident took place, my lord, the rate of interest, we can place the judgment on record, my lord, was 12%, my lord, earlier, my lord.
No, no,
At that-
you are deriving some, your submissions are based on the Supreme Court judgment, which has based its findings on the Upahar Cinema case.
Lord.
And this award is of the year 2009. Upahar Cinema judgment came much later.
Lord, there will be two factors. One, my lord, interest can be.
So only because it was granted in Upahar, it cannot be
No, not on that only.
logical on our part,
Yes.
because that was non-existing.
Yes, Lord.
But you can base your own, your submission,
Lord,
or
my,
after your own submission, that this is the thinking,
Lord,
that 6% is of the lower side.
Yep.
And even other statutes have fixed interest rate, which is more than 6%.
more than.
So at
That
least
is-
9% should be the case.
That is one part of my submission, Lord. Earlier, if your lordship said, Lord, the problem has arisen, Lord, because 171 has not fixed any rate of interest, Lord. So
That is
earlier,
up to the legislators, it's up to their wisdom. In WC,
there has,
in arbitration, there is a fixed rate of interest in LA case, but here it's not there.
it's not there, Lord.
There may be some,
Lord, but can, Lord, in
no,
MSC
we
cases,
cannot go into that aspect now as a court. We cannot go into the competency of the legislator. Why they have not put an
No,
interest?
what happens, my lord, when in
We
a
only have to see that whether the interest which has been given rate of interest is a reasonable rate or not.
Correct.
Is it commensurate to the normal rate of interest that's going?
second, my lord, the principal argument here would be, my lord, when in a similar statute, my lord, a rate of interest is prescribed, my lord, and whether that rate of interest should be applied in this case or not, in MSC cases or not, my lord. That will be also be a question, my lord, here to be determined. One. Second, my lord, the rate of interest, if you see the judgment, my lord, from 90s onward, my lord, what we find is, my lord, that earlier it was even 18% from 90s, my lord. Then it comes to, my lord, 12%, my lord. Then it goes on gradually decreasing, my lord. But my question, my lord, before from a learned friend that I raised, my lord, here is, my lord, whether, my lord, in a case, my lord, other act case in, my lord, why did step motherly treatment with the MV Act, my lord? Here, a person has died or a person has lost his limb, my lord. So whether it is fair to award so less an interest in comparison to all other acts that has prescribed some rates of interest, my lord. That the discretion has, they have not left the discretion to the court, my lord. So whether these principles should not be applied in my case also, my lord. That is also one part of my submission, my lord. And why I am in a recent case, my lord, Rajesh Tyagi case, my lord, where the Supreme Delhi High Court, my lord, has laid down the entire procedure how to MSC case needs to be decided, my lord. In that case, my lord, the Delhi High Court has stated, my lord, that suppose a person met with an accident, the insurance company come after 1 month and says that, okay, you are claiming 10 lakhs rupees. As per our opinion, we can give you 5 lakhs. You take this 5 lakhs, you continue with your case. Then the rate of interest should be low. But we cannot give a premium to the insurance company for withholding our money, my lord. That's here, my lord, in all other cases in Guwahati, Assam, that we are finding, my lord, our state, my lord, that there is no approach of the insurance company to settle the dispute, or there is no approach to say that, all right, we will give you to this much extent, you continue with the litigation fee, you are entitled to this extent, my lord. That is not there, my lord. So what they are getting is, they are
No,
getting
that
it.
is why the interest is given from the date of filing of the claim.
Yes, my lord, but 6%, my lord, is on the lower side. They're getting a premium on that, my lord. They're earning more money by keeping our money, my lord. So that should not be permitted. Now, next judgment is, my lord, of the Supreme Court. It is Srimati Chameli Vati, my lord. Here 1986 Supreme Court. Here 12% was granted, my lord.
What is the name?
My lord, it's Chameli Vati, my lord, and another. 1986 Supreme Court 1191, my lord.
Why aren't you referring your case in order to your filing?
Third number, my lord, fourth, my lord. After that, Puspa judgment, my lord, Puspa Maheshwari judgment, my lord. After the Puspa Maheshwari judgment, that just be available. There are only 2-page judgment.
Santilata.
No, not Santila. Before that, before the Santila, my lord. Again,
Pushpa Maheshwari is your
after Puspa Maheshwari, my lord, 2-page long. May I read only one paragraph? No, Lata, not Lata. I think that we have not supplied it.
After Pushpa, you have given a judgment, Dr. K.R. Tandon.
No, my lord, that is not there, my lord. We will give a copy, my lord. Yes, sir. This case, my lord, page 2, my lord. We'll read just one portion. My lord. The learned single judge as well as the division bench totally ignored the fact that the enhanced amount of compensation awarded by Milord, paragraph 2, Milord. Second page.
Yes.
Will Lord just read the mark portion, Milord. The learned single judge as well as the division bench totally ignored the fact that the enhanced amount of compensation awarded by them was in their judgment correct amount of compensation payable to the appellant on account of death of the deceased resulting from the accident. The learned single judge and the division bench should not have therefore awarded interest on the enhanced amount of from the date of the application. We accordingly set aside the judgment of the division bench and as also the judgment of the learned single judge. So far as the judgment directs that interest shall be payable on the enhanced amount of compensation from the date of respective judgment. Lord. In this case, 12% was awarded. Lord.
No, the Supreme Court did not say anything about the percentage.
Lordship?
The
Yes.
Supreme Court has not said
Not
anything.
said,
about it,
in this
only
case,
on
he
the
has
date-
not said, but
date
yes, Lord.
From where, when the interest would be accrued.
Lordship?
In this case, it is only the date from which date the interest would be accrued.
Lordship.
That has been laid down.
Lord.
Percentage was.
Percentage is not there, but not, 12% was awarded. Lord.
12% was awarded by the High Court itself.
12% was awarded on that was not, my Lord. At that, if your Lordship, Lord, I am again coming to that, Lord, we'll place judgment, if your Lordship says, Lord, 90s, Lord, it is all 12%, Lord. 2004, Lord, 12 to 9%, Lord, from 2000, in the year 2000. It is start decreasing, Lord, after 2007, 8, Lord, 6, like that, Lord. And though there are certain judgment, Lord, which says, it should be that much, Lord, that was never followed by the tribunal. Still, Lord, there is no settled law, Lord. What should be the rate of interest? It's always left in the discretion of the court, of the tribunal, Lord. So what extent, Lord, which can leave this amount to the discretion of the tribunal, Lord? That is also the court mechanism, Lord. Now, Lata Agarwal, we have already stated, Lord, here in this case, basically, Lord, all the different acts, Lord, what is the rate of compensation is there, Lord? Not go on that, Lord. Now, this is the judgment, Lord, 2021, just by Justice Chandrachud, Lord, Santhila Sethi, Lord. In this case, Lord, the entitlement comes, Lord, from the date of the accident, Lord. That fact has written. The day I met with an accident, I am entitled to interest, Lord, because there I am entitled to the amount that this Lord, this honorable court would decide, Lord, on the basis of the accident that happened in 2004, Lord.
But if you are late in approaching the court,
Lord, but then also, Lord, my submission is, Lord,
suppose
I
you
am
come to the
entitled
court after 5 years.
after 5 years, Lord. But I have, Lord, my entitlement for that money, Lord, was on that date, Lord.
No, we have to balance the equities.
Lord, they are
You
keeping
did
my
not,
money,
you
they
did
are
not
earning,
come to agitate your right.
they are earning the profit from my money, Lord.
No, you thought that you took 5 years.
Lord,
The insurance company may very well say that you should have come earlier.
Lord, that can also be a principle, Lord. But my submission here is, Lord, if I am entitled to some money on a particular date, Lord, and that money is being kept by someone else, Lord. That is why interest is being paid, Lord.
See, these are matters of adjudication.
Lord.
Your entertainment comes, it fortifies it only on the adjudication of the claim.
Right.
Prior to that, prior to an adjudication, you cannot say that this money is mine.
That is what the Champa, but it says, Lord,
No,
that on the
see, there are many MSC cases which are also dismissed.
Lord.
Frivolous claims,
Lord.
whatever.
Lord.
Before an adjudication is made, before your right crystallizes after the adjudication.
Lord.
You cannot say that
But
my money was held up.
Agreed, Lord.
It is not like some premium being paid,
Lord.
and it is some different kind of a claim.
Lord, if we go into this arena, Lord, when the insurance company raises the question of, Lord, that insurance policy is not valid, Lord, at that point of time, if we see the lordship view, Lord, that may to a certain extent, Lord, we may agree. But when there is no such question, Lord, so that
See, your argument may not be accepted for another reason. Whatever you claim is not given by the
Lord.
You have the right to file and appeal for enhancement. That's a different matter.
Lord.
But after all, it is after the adjudication, the awarded amount which becomes your entitlement,
No.
which you can go for an execution.
Lord.
And prior to such a adjudication process, saying that I am entitled to this amount, that perhaps will be a little.
Milord, I agree with it. That's why when Delhi High Court says that, Milord, when the insurance company come forward, Milord, when there is no defense available to
But
them,
that is, I think,
to,
that is, I think, a very good.
yes,
suggestion.
Milord, the judgment will
That
place.
if it is made, that offer is given to
Yes,
you,
Milord,
that you accept this,
this accept this.
then at least the rate of interest could
Yes,
be
Milord, then it
brought
can
down
be.
to a minimum.
met.
And not only the rate of interest, even the total amount of interest could be less because the one part has already been paid.
Yes. That you will. Now, this judgment, Milord, this judgment
This,
basically,
which paragraph do you rely upon?
Milord, this two judgment, Milord, they basically, Milord, 5 and 5, paragraph 5, Milord. On appeal, may I, Milord?
Yes.
Paragraph 5. On appeal, the High Court by judgment dated so and so modified the award, reducing the compensation to rupees so and so and the interest from 12% to 8% from the date of the award till realization. The High Court has, while reducing the claim for compensation, proceeded on the basis that there was no material on the record to indicate the salary of the deceased at the time of the death was so and so. The High Court consequently proceeded on the basis of a minimum wage of so and so to which the multiplier so and so was applied, resulting in a recomputed compensation of so and so. On the point of interest, this court held that there is no provision in the Act to grant interest on the compensation from the date of the accident. Subsequently, the payment of interest was reduced from 12% to 8% from the date of the award. The review filed against the judgment was dismissed by order so and so. On behalf of the applicant, it is submitted that the High Court has completely failed to consider that the award of interest is governed by Section 4 of the Act. Moreover, it has been submitted.
Findings, these are,
Not a finding in the next minute. The question, para 21, Milord, 20 and 26, 20 and 21 is the finding, Milord.
no, those are of Northeast Karnataka road.
Lordship.
In this case, what are the findings?
Milord,
And
paragraph 6, Milord.
Six.
Sub para 20, Milord.
Six.
Paragraph 6, sub para 20, Milord.
This is part of Northeast Karnataka road.
Yes, Lordship.
Where are the findings in this case?
But as early in 1975, 4 judges bench of this court in so and so, speaking through so and so has held that an employee becomes liable to pay compensation as soon as the personal injury is caused to the workman in the accident which arose out of in the course of the employee. It is accordingly held that the date of the accident and not the date.
This is in terms of a WC case.
Yes, Milord. That,
And that was the Pratap Narayan.
yes, Milord. Pratap Narayan Singh.
Where is the finding in this case? Satilata. You have read paragraph 5, 5 is just the sufficient. 5 is not the.
Basically, it relied on this 4 judges bench decision and concluded that only, Milord, that it is from the date of the accident, Milord.
Where?
Accordingly, that in the date of the accident, the appeal of this was in a manner in which the litigation dragged for a consequence of from a long run.
This is also WC case.
Lordship.
It's not a MSC case.
Lordship.
Okay, next.
Milord, next judgment is page 5, Milord, Ajaya Das case, Milord. The last line, it is relied on, but it has come to a clear finding, Milord. Last line, last paragraph, Milord, first page, paragraph 5. In so and so case, this court has held that interest shall be paid on the compensation awarded from the date of the accident, not from the date of the adjudication of the claim in view of the decision of this court. In so and so, wherein it was held that compensation would fall due from the date of the accident Further, in the recent decision of so and so, this court has reiterated that the applicant is entitled to interest from the date of the accident, while rejecting the submission that the award of
Which,
interest,
what's the reading?
the paragraph 5, last line,
Oh,
first
Ajay,
page,
Ajay,
Ajay, my lord. Last line, my lord, first page, my lord, paragraph 5.
this is WC case.
This is WC case.
There is also WC.
Last, that is, my lord, with regard to the interest, that is my submission, my lord. Which is again to complete.
Yes.
One last judgment will refer to Milord with regard to Milord question that were not put in cross-examination. Milord. That is EIR 1961 Calcutta 359. Milord.
See, just now you have submitted that the strict rules of evidence will not be applicable.
Lordship, yes, but in cross-examination, at least the question.
You are bringing in the strict rules of evidence.
No, Milord, on my only submission, Milord.
You have to be consistent in your.
Lordship, Milord. My only submission is Milord.
If you
When
feel
in cross-examination,
questions were not put and will go to different aspects.
Lordship, Milord. No, Milord, only question is Milord, if in cross-examination some questions are put to me, Milord. In this circumstances, I have the right to rebuttal that aspect, Milord. Now, Lordship is just one paragraph, Milord. We will read. It is 1961 Calcutta High Court. It happened.
Yeah.
AI 1961 Calcutta. Milord. Now we have submitted. Daza, अपना इतना judgment दिखी. 1961 Calcutta. Oh, I do. 60 HP ला है. it. Page 5, Milord. Paragraph 10, Milord. Paragraph 9 and 10, Milord. 9 will read only first 3 lines, Milord. Failure to put important and crucial part of the case to the witness coming to prove the testimony capacity must be held against the respondent, Milord.
Paragraph 5.
Paragraph, page 9, paragraph 9, Milord, page 5.
Yes.
Page 9, paragraph 9, Milord, just 3 lines. Failure to put the important and crucial part of the case to the witness coming to prove the testimony capacity must be held against the respondent. Now the answer is at paragraph 10. Milord.
Yes.
The law is clear on the subject. Whenever the opponent has declined to avail himself the opportunity to put his essential and material case in cross-examination, it must follow that he believed that the testimony given could not be disputed at all. It is wrong to think that this is merely a technical rule of evidence, the rule of essential justice. It serves to prevent surprises at trial and miscarriage of justice because it gives notice to the other side of the actual case that is going to be made out when the turn of the party on whose behalf the cross-examination is being made comes to give and lead evidence by producing witnesses. It has been stated on high authority of the House of Lords that this much a counsel is bound to do when cross-examining, that he must put to each of his opponent witness in turn so much of his own case as concerned that particular witness or in which that witness has initiated. If he asks no question with regard to this, then he must be taken to accept the plaintiff account in its entirety. Such failure leads to miscarriage of justice. First, by sparing surprise upon the party when he has finished the evidence of his witness and when he has no further chance to meet the new case made, which was never put. And secondly, because such subsequent testimony has no chance of being tested and corroborated. On this point, Lord, this judgment, House of Lords judgment is there, Lord. Now, my Lord, I cannot help saying that it seems to me to be absolutely essential to the proper conduct of a cause where it is intended to suggest that a witness is not speaking the truth on a particular point, to direct his attention to the fact by some question put in cross-examination, showing that the imputation is intended to be made and not to take his evidence and pass it as a matter of altogether unchallenged. And then when it is impossible for him to explain as far as he might have been able to do so if such questions have been put to him, the circumstances which is suggested to indicate that the story he tells ought not to be believed, to argue that he is a witness unworthy of credit. My lord, I have always understood that that if you intend to impeach the witness, you are bound while he is in the witness box. To give him opportunity of making an explanation which is open to him and as it seems to me that it is not a rule of professional practice in the conduct of a cause, but is essential for a fair play and fair dealing with the person. Now, my lord, coming back, my lord, to the point, my lord, that Lordship has raised, my lord, that 40, my lord, it can be, my lord, by any, it can be a mistake also, my lord. How it was put at this stage, we cannot know, my lord. At this stage, we have only two documents on record, my lord. One is the birth certificate, school leaving certificate, and the other is the postmortem report. So, in that background,
Which part,
Lord,
you're not too much, you had concentrated on the income part. Income part,
Lord,
we may have a second. Each part, you're not too much.
we'll leave it to that, we'll leave it to Lord.
Yes,
This is-
Mr. Doctor.
Lord, one more point is there, my lord. Now, after this, my lord, there is when a Sarla Verma case, my lord, there has been a sea change, my lord, in MSc cases, my lord. Now, Pranesh, after the Pranesh Shetty case, my lord, constitutional bench judgment, my lord, if lordship takes it up to 40 years, my lord, my age, my lord, the addition will be 40%. 41 to 50, my lord, the addition will be 25% of the actual income that is calculated, my lord. In addition, my lord, what we will be entitled to in the matter is, my lord, loss of consortium, loss
See, judgment
no,
of Pranay Sethi,
no.
can you make it applicable for?
Yes, my lord. In every case, it does make applicable, my lord, because Pranay Shetty judgment is 2017, my lord. Accident which have taken place earlier than that, my lord, they are making it applicable, my lord.
Now, this is the case where an award is of the year 2009.
My lord.
Award was based
The
on the.
Sarla Verma judgment, my lord, came before my judgment, my lord. If your lordship
And
thinks
this award was based on the existing law, existing case law.
my lord, it is interpretation when existing law would be the motor vehicle act, my lord. The interpretation would be by the apex court regarding this law, my lord. The interpretation would apply, my lord, to that. There is that law, that part has also been settled by the Supreme Court, my lord, in judgment, my lord. If your lordship says we can produce that, my lord, judgment also.
No, judgment normally has, it's not a law by the legislature that
Lord,
will have.
It is only interpretation. my lord.
Judgment will,
Yes,
there's no question of non-application of law,
Lord,
unless it is barred by law,
unless.
or the judgment specifically states.
Yes.
Like Ramzan Khan,
Yes.
date was fixed,
Yes.
cut out date. But normally, yes, so
Firstly, your lordship has rightly pointed out regarding age of the deceased. As per Exhibit 9, the age was 45 years. And if your lordship comes to Exhibit 7, their
just a minute. Exhibit,
7 trade license, their trade license.
trade, guys.
Yes.
Yes.
There, the date of issue, your lordship will find 1987. So 34 years. Then on the date of accident, that is
Just a minute,
2004.
just a trade price. 87.
Yes.
34 years.
Yes, 34 years on the
Hmm.
date. So in the year 2004, his age will
This,
be 51 years.
Trade license, 34, the digit is written, but it is not written against any category, any column of age.
Yeah.
We are
that-
just deducting, because
Yes.
it's written against Khan, the resident.
But it
It may be,
appears to
age,
be 34.
maybe age, but
Hmm.
you cannot conclusively say that it is.
Yes, yes. It's not conclusive.
We just,
Otherwise, the
we
age
just noticed, therefore, perhaps it's the age, but we cannot just say that. it's
secondly, regarding the income, the
on age,
age should be 45 years, rightly held by the learned tribunal.
basis,
Basis the PM report.
no, PM, he says that there is a, to counter the PM report, there is a school transfer certificate.
Yes. I'll say that that was under objection. A lot of people find at page,
Yes, we have seen.
yes, page 32.
Yes, yes.
That is under objection. So team report that will prevail.
Now, why haven't you seen in the, you are not privy to this fearless?
Yes, that is also that peerless document.
Hmm.
Exhibit 9, page 52.
Hmm.
That also shows that
He was 40,
yes, he was 40 in the year 1999. So,
so 34 is, 44 is absolutely perfect.
44. Then he'll come in the range of 41 to 44 for taking the multiplier. Now, if your lordship comes to page 64
Of
of the
compilation,
yes,
part of the judgment.
yes, that's part of the judgment. They're above the award passed. Towards the end, your lordship will find the line start with so under such circumstance.
Yes.
The age of the deceased can be considered in between the age group of 40 to 45 years for the purpose of computation of the compensation. And as such, the appropriate multiplier would be, it should have been 14 instead of 15. Sarla Verma table says that 41 to 45, the appropriate multiplier will be 14. Paragraph 30 of that judgment, 2009-6 SCC 121, Sarla Verma.
Answer has been taken as 15.
15.
Should be 16.
It should be 14
As per Sarla Verma.
as per Sarla Verma.
Give the citation of Sarla Verma.
2009-6 SCC 121.
Hmm.
And now I'll come to the income part.
But there is no cross appeal from your part.
Yes.
So 15 you have accepted.
And number 2, income part. That regarding this exhibit 6.1 and
Page.
6 is in income certificate is in page 47. 47 and then 48. 6 and 6A. Lordship will notice that both the certificates, they were issued in the year 2008. And secondly, one was issued by the village headman and the next one by president of one Hindustani Sammelan. So the court in the Guwahati High Court has said that such certificates are of no value. It does not have any admissible evidence. So I'd like to cite those judgments.
Yes.
In Oriental Insurance versus Cecilia Marbanian, that is 2009 SCC online GAU 74 and
2009 SCC
online GAU
Guwahati 74.
74.
Name.
In Oriental Insurance versus Cecilia Marbanian. And second one, 2007 3 GLT 444. This is New India versus Kalyan Thanga. These are the copies.
Yes. In the first case, oriented, what is the paragraph?
Paragraph is paragraph 19.
19.
Yes. May I read it out?
Yes, please.
It is the admitted position that the OP Appellant Insurance Company as well as the OP did not adduce any evidence before the learned tribunal. According to this court, the income certificate issued by CW to the village headman, on the basis of which the learned tribunal assess the income of the deceased, cannot be treated as a proper income certificate, as he is neither authorized by law to issue such certificate, nor he is the employer of the deceased husband of the claimant respondent. In this situation, the court has to consider what should be the real daily income of a water carrier to slaughterhouses like the deceased, as there was no valid document before the learned tribunal in support of the income of the deceased husband of the claimant respondent. The income should be calculated considering the daily wages of a daily laborer. Nowadays, daily laborer's income is not less than 100 per day. Even sometimes it is more than 150 per day. This is in Sicilia Marvini, and in Kollian Thanga, paragraph 5 and 6. I'll read it out. Paragraph 5. Mr. George Raju, learned counsel for the appellant, submits that the method of calculation adopted by the learned tribunal is wrong and arbitrary, inasmuch as there is absolutely no proof on record to submit that the deceased was earning.
Kohima Ben, Kohima Ben.
Yeah, Aizawl bench.
I told.
Yes. The only documentary evidence in support of the claim is a certificate issued by the president of the village council, marked as Exhibit C4, which does not disclose the source of income or the nature of occupation of the deceased. Even the claimant, the elder brother of the deceased, in his deposition has stated nothing as to how the deceased was earning 40,000 annually or to what extent he was dependent on him. Though learned counsel for the claimant respondent strongly opposed this submission by submitting that the certificate being admitted without objection cannot be called in question of the appellate stage, I do not find any force in the same. Even after a document is admitted in evidence, it remains to be appreciated with regard to its evidentiary value. It is not difficult for any person to obtain such a certificate from a village council, and by merely producing such a certificate, the burden of proof on the part of the claimant does not stand discharged. Now, Your Lordship, my learned senior was saying that we did not cross-examine. So first, they have to discharge their burden. They have not discharged their burden. They have only produced a certificate which they could not prove. So the question of cross-examination is not necessary in that case. So these are the two copies, Your Lordship. Then regarding
Just a
yes.
Yes.
Now regarding this, when the claimant cannot establish their income, the Supreme Court has said under such circumstances, the prevailing wages as per Minimum Wages Act, that is to be taken into consideration. That judgment is, Your Lordship, Kirti and another versus Oriental Insurance Company Limited, reported in 2021 2 SCC 166. This is a copy for you, Lordship.
Give the citation again.
2021
2021.
2 SCC 166.
Name?
Name is Kirti and another.
Kirti.
Yes, KIRTI and another versus Oriental Insurance. Now, para 11. I'll read it out once. Second, although it is correct that the claimants have been unable to produce any document evidencing Vinod's income, nor have they established his employment as a teacher, but that does not justify adoption of the lowest tier of minimum wage while computing his income. From the statement of witnesses, documentary evidence on record, and circumstances of the accident, it is apparent that Vinod was comparatively more educationally qualified and skilled. Further, he maintained a reasonable standard of living for his family as evidenced by his use of motorcycling for commuting. Preserving the existing standard of living of a deceased family is a fundamental endeavor of Motor Accident Compensation Law that at very least the Minimum Wages Act of rupees 6,197 as applicable to skilled workers during April 2014 in the state of Haryana ought to be applied in this case. So this is a case of 2014. Now, in this regard, another judgment passed by this Honorable High Court in MSc Appeal number 539 of 2018. MSc Appeal 539 of 2018. Miss Rushi, RUSHI versus Oriental Insurance.
Are you SH or CHI?
RUSHI at the rate of RUCHI.
Not at the rate of, also known as.
18. There, the relevant para, which I would like to rely is paragraph 10F.
Judgment dated
Judgment dated 2023.
28th of February,
Yes, 20th of February.
23.
Yes.
By Honorable Justice.
AD Chaudhary. 10F will be the relevant portion. I'll read it out once. At the relevant point of time, the
10F.
minimum 10F. At the relevant point of time, the minimum wages under the Minimum Wages Act, the state of Assam had notified the minimum wages of an unskilled labor to be 169 per day, and therefore the monthly income of an unskilled labor will be 5,070. This code, following the principle laid down in Ayush Chopra and Kajal Chopra, assumes that in worst case scenario, even ignoring the good career of the victim would have been able to earn minimum wages of an unskilled labor. It is well settled that determination of that is regarding loss of earning capacity. So this is the judgment. And lastly, regarding the rate of interest, the Supreme Court has said that under this MV Act cases, the rate of interest should be determined by taking into account the current economic scenario into consideration. So I'd like to rely on 2001 2 SCC 9, Kosnuma Begum versus New India Insurance.
Give the citation.
2002 SCC.
2002,
Yes. 2001 2 SCC.
2001,
2 SCC 9.
9.
Yes.
Paragraph.
Paragraph 24. I'd like to rely upon. Now we have to
Kosnuma.
Kosnuma. Para 24 there, your lordship. Now we have to fix up the rate of interest. Section 171 of the MV Act empowers the tribunal to direct that in addition to the amount of compensation, simple interest shall also be paid at such rate and from such date, not earlier than the date of making the claim, as may be specified in this behalf. earlier 12% was found to be reasonable rate of simple interest. With a change in economy and the policy of RBI, the interest rate has been lowered. The national banks are now granting interest at rate of 9% on fixed deposits for 1 year. We therefore direct the compensation amount fixed herein shall be bear the interest at the rate of 6%. So nowadays the rate of interest as per RBI is 6 to 6.5%. So I'd say that the judgment passed by the learned tribunal at 6% that should be maintained. And regarding my learned senior submission, that
Just
in-
a minute.
yes.
Here, in 24, 9% was allowed.
Yes, 24, 9% was allowed. But now your lordship will find the rate of interest on fixed deposits, that is 6 to 6.5% are being awarded. Or at maximum 7%.
More than 7.
So anywhere between 6 to 9. And regarding the submission, that interest should be calculated from the date of accident. That is only in regard to workman compensation
W-
cases. That was held in Pratap Narayan Singh Dev. So this is all.
Anything else to conclude?
Lordship, we can, Milord, only thing, Milord, that the first judgment that we have cited, it is from the date of, Milord, accident or the date of filing of the claim petition. Then claim, Milord, one. The second is, Milord, that we have already stated, Milord, that in other act, and it is, Milord, 24% and 12% is the minimum, Milord. That should be the calculation. It should not be any step motherly treatment with MVA.
We have that. Mr. Chaudhary, which matter? Hearing matter.
Hearing.
Other side,
Other side, Mr. Sayawala.
what is the matter?
This is a matter regarding specific performance of a contract which was decreed, my lord.
You are on second appeal.
No, one. First step.
First appeal. You are against, you are the defendant.
I am the defendant.
Let us see. If you pass the judgment, it's taken up.
Can I pray that that will be taken up on some other day, my lord?
You have difficulty.
I have certain problems with my mother is not well. I think support.
At 2 o'clock, so right now we are not saying anything.
In the second division, then some matters are going on. Some difficulties on my part, not either lordship may kindly taken up as a last item or for the date.
We'll have it in the last item.
Lordship,
We'll dictate a judgment now.
I'll come back. I'll come.
We'll dictate a judgment now. So hearing is over. After the judgment, we'll take.
But some matters are there, Manoj. Immediately the matters are over, I'll.
May I take the indulgence of the lordship for a minute? Lordship, item number 11. Lordship, I have been served a copy of a IA which has been filed today by the appellant side. Can it be taken up in the first around in the month of September? IA under order 39 to bring on record some new documents which was not there at the time of the trial.
Order 39.
Or order 47 rule 11.
41 rule
Sorry,
27.
order 41 rule
27.
27.
Additional evidence.
Additional evidence at the appellate stage.
Yes.
What kind of evidence?
Lordship, insurance policy and the GD entry, Lordship. And they want to.
I need to file an objection to that, Lordship.
Let him file objection.
Lordship, can you?
Your IA is otherwise not on record.
Not
No,
on
Lordship,
record.
today we have filed.
Can it be around the 11th of September, Lordship?
11 to Monday or 12.
Your G was coming.
R. Sharma,
Your R. Sharma.
Lordship, for the appellant.
Sri R. Sharma, Learned Counsel for the appellant, submits that an IA has been filed under order 41 rule 27
27.
CP for allowing adducing of additional evidence of Sri M. Das, Learned Counsel for the payment. However, submit that he would like to file an
Okay.
objection for which he has prayed for some time. Saptara. Please, when,
On 12th of September, Lord.
please, after days, please after 4 weeks,
4 weeks, Lord.
4 weeks to enable filing of the
Obliged, Lord.
Obliged, Lord. Item number 14, my lord, can I be excused today? my lord?
Where is the other side? Madam, you're with Mrs. Sayola? You're with Mrs. Sayola? He got some matter, he wants some time.
Lordship.
You need some big date,
Lordship, that will be better any date in the month of September.
tell us,
Or any date convenient,
this is of which year?
2019.
19,
Item number 14.
14, my lord.
Three D Chaudhary Learned Counsel for the appellant. Praise for an adjournment due to some personal reasons. As your S2D
Yes, Lordship.
also heard MS S2D Learned Counsel for the respondent. Respondent numbers 1 to 3. Full stop, para. As agreed to by the parties, please, the matter is adjourned and adjourned to be listed on
11th of September.
11th September is
Lordship.
okay, 11th September is what?
Monday, Lordship.
Monday.
I'm deep.
11th.
Obliged, Lord.
This is item number 4. With the passing test. No point keeping it pending. The instant epic has been preferred under section 173 of the Motor Vehicles Act 1988 with regard to a judgment and award dated 28/4/2009 passed in MSC case number 175 of 2007 within bracket earlier registered as MSC case number 2418 of 2004 by the learned additional district judge FTC number 2 Kamrup. Full stop. The grievance of the appellant who is with regard to the adequacy of the amount awarded. Full stop. By the impugned judgment, comma, an amount of rupees 4,89, 500 has been awarded with interest to be paid at the rate of 6% from the date of filing of the claim. I have heard the A. Lal Learned Counsel for the appellant, whereas the insurance company is represented by Sri Siddhant Datta, Learned Counsel. Full stop. Before going to the grounds of challenge and issues involved, comma, it would be convenient if the facts of the case are narrated in brief. Full stop. The claim has arisen from the death of the predecessor of the claimant. While the appellant claimant number one is the wife of the deceased, comma, the rest of the five appellants public claimants are the children. Full stop. The mother of the deceased was also arraigned as pro forma respondent in the claim. Full stop. The death had occurred on 22/9/2004 in a motor vehicle accident, and such accident is not the subject matter of dispute. Full stop. The claimant had stated that the deceased name
Ram Prasad, Lordship.
Ram Prasad had business and had two shops of electronic items. One at Bonihar,
One, yes, Lord. One 13 mile, Lord.
one at Bonihar,
Bonian,
and one at
Lalmati Guwahati.
Lalmati, Guwahati. And used to earn at least rupees 15,000 per month. Full stop. As regards the age of the victim, comma, that was claimed to be 34 years at the time of the accident. And the number of dependents being 8, comma, an amount of rupees. How much did you claim?
No, 35 lakhs, Lord.
An amount of rupees, a claim of rupees 35 lakh was made in the claim petition. 4 numbers of witnesses were produced before the learned tribunal, including the claimant number one, the wife of the deceased, comma, an elder brother of the deceased, comma, an employee of the deceased, and
Lord, one brother and employee, Lord. Younger brother and claimant number one.
two brothers of the deceased. I was it, yeah, elder brother, no, 2 brothers of the deceased, and an employee. As regards the age, comma, apart from the statement made by the claimant number one as TW1, comma, the school transfer certificate was produced, as per which the date of birth of the deceased was stated to be 15/12/1970, as per which, comma, as on the date of the accident, comma, his age would have been about 34 years. With regard to the income, comma, two numbers of documents were exhibited, one by the village headman and the other by an organization, wherein it was stated that one by an organization. The learned tribunal. However, by the impugned judgment and award had taken the monthly income to be 4,000 rupees and the age of the deceased as 44. 44.
40 to 45, my lord.
What was the age taken?
No definite age was given, my lord.
And the age of the deceased was taken to be in the range of 40 to 44.
Right.
And accordingly, 42,
45, right.
45. And accordingly, the aforesaid figure of 4,89,500 was arrived at. The rate of interest which was directed to be paid was stipulated to be 6% per annum from the date of filing of the claim. Sri Lal, the learned counsel for the appellant, has based his claim for enhancement on the following broad aspects. Hold on. Number one, the age of the victim, which was held to be in the range of 40 to 45, was erroneous and perverse in view of the documentary proof as per which the age of the victim of this is was 34 years at the time of death. Number two, the income of the deceased, which has been taken to be rupees 400 per month on notional basis, is contrary to the evidence on record, as per which the said income was proved to be at least rupees 15,000 per annum. Number three, the rate of interest which has been awarded that is 6% per annum is on the lower side and not reasonable. Additionally, Sri Lal has also raised the issue that the learned tribunal has overlooked the aspect of dependence, as there were as many as 7 numbers of dependents of the deceased who were leading a reasonably decent life. By elaborating his arguments, the learned counsel has drawn the attention of this court to the evidence of the appellant number 1 who had deposed as TW1. Mrs. Tayawala, any matter of yours?
Item number 10.
One we have
14,
adjourned.
my lord, in fact, my lord, that matter was admittedly 60 lakhs they have to pay to sisters. Fathers are not paying, your lordship fix the matter for hearing without passing an interim order. My lord,
No,
they mentioned it.
some mention was there. Your junior was there, so we
But
on our
they have not informed me, my lord. actually.
no, on our consent only we had said. Because the mention was made even in the first, we said we are not going to pass orders.
Anyway, my lord,
We had passed the 11th.
but
I think.
actually nothing has been paid.
Okay, 11th, you remind us.
My lord.
Any other matter now?
10 item is there, my lord.
This will take some time. We're dictating the judgment. You can come up to some Mr. Royal, you can come after.
It's 2001, my lord.
This,
22
this
years.
will take at least half an hour to complete. Claimant number one, STW one. In the state evidence, it was stated that the deceased was the sole earning member of the family, and after his passing away, there is no source of income. Full stop. It has further been stated that the deceased was an able-bodied person who had two shops of electronic goods, one at Lalmati, Guwahati, and the other at 13th mile under Burnihat, 13th mile, Burnihat, and had dealt in electronic goods and had also engaged employees in his shop on monthly basis. Full stop. His monthly income was stated to be rupees 15,000, and it has also been stated that in the post-mortem report, no, uh, no, 15,000. As regards the age of the deceased, attention of this court has been brought to the transfer certificate issued by the school in question, as per which the date of birth was 15/12/1970, and the said certificate was issued in the year 1992. Full stop. It is submitted that in view of such categorical proof regarding the age, relying on the age which was recorded in the PM report as 45 years, could not have been made, which has caused serious miscarriage of justice. Full stop. He submits that the age which can be deduced from the aforesaid transfer certificate would be around 34 years at the time of the accident. Full stop. The learned counsel has also referred to the cross-examination of the state CW1, where the cross-examination as well as the re-examination of the state CW1 the cross-examination and not re-examination, this is further cross-examination. And the further cross-examination of CW1 from where it appears that no specific question denying the claim was put upon her, and therefore there was no scope for any rebuttal. Full stop. Reliance has also been put on the evidence of the elder brother of the deceased who had deposed as CW2. Full stop. In his same deposition, comma, he has categorically stated that the deceased was 34 years of age at the time of the accident, and such categorical assertion was maintained at the time of cross-examination. Full stop. CW3 is an employee of the deceased who has who had deposed that he was paid a monthly wage of rupees 5,000 by the deceased, and another employee was paid rupees 7,000 per month. Full stop. CW4 is the younger brother of the deceased, and who also worked as an employee under him, and he had supported the earlier the verses of the other witness with regard to shops of deceased. Full stop. The trade license which was issued by the Guwahati Municipal Corporation was also exhibited before Learned Tribunal as exhibit number 7. The license appears to be of the year 1987, which was valid up to 1999. Full stop. Certain insurance policies of Peerless PRLS were also exhibited. Full stop. Resolved the Learned Council by referring to the impugned judgment has submitted that the Learned Tribunal had come to a finding that the income certificate was not properly proved, and there were no books of accounts. Full stop. He had also come to a finding, the Learned Tribunal had also come to a finding that in absence of that there were no concrete evidence with regard to the income, and therefore a notional income of 4,000 per month was adopted. The Learned Council submits that the findings of the Learned Tribunal are not only unreasonable but also not in consonance with the material which were proved by the claimant in the proceeding. The Learned Council for the appellant has relied upon certain judgments on to support his contention on the point of income, comma, the following judgments have been cited. Dot, 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 point. Sarah, on the adoption of the rate of interest by a tribunal, comma, he submits that under section 171 of the Act, no specific rate of interest has been prescribed. He has drawn the analogy with similar acts like the employees, what is it called? Employees Compensation Act. Earlier, within bracket, earlier Workmen's Compensation Act, bracket close, comma, the Arbitration and Conciliation Act, 1996, and which one?
Consumer Protection
And
Law,
Consumer
Land
Protection
Acquisition.
and comma, Land Acquisition Act. And comma, Consumer Protection Act, etc., wherein a specific rate of interest has been prescribed, and such rate is more than the rate which has been granted in the present judgment.
The minimum is 12%.
He submitted that in all such enactments, comma, the minimum rate of interest prescribed is 12%. And all the aforesaid acts being beneficial legislation, comma, a uniform practice should be followed by the tribunal while granting interest. Where on the supporting the aforesaid contention, comma, the learned counsel has relied upon the following judgment. Where Sri Lal has also submitted that the learned tribunal has acted on surmises and conjectures as there were no materials to arrive at the conclusion as done in the impugned judgment. He submits that if an adverse party to a litigation is actually interested to put in a defense, comma, a specific question is required to be put in the cross-examination, which was lacking in the instant case. And therefore, the positions made in chief were almost unrebutted and should have been accepted. In this regard, comma, the learned counsel cites the judgment of the Honorable Calcutta High Court instance. Sri Lal accordingly submits that the present is a fit case wherein this court, in exercise of its appellate jurisdiction, would interfere and direct adequate announcement of the award. For contrast, Sri Datta, the learned counsel for the insurance company, has submitted that no grounds, that none of the grounds cited are able to be substantiated by the appellant in the instant case. By dealing with the aspect of the age, comma, it is submitted that admittedly there were 5 children of the deceased, and if his date of birth is taken to be 1970, comma, it would be almost unreasonable to come to a situation that the disease, that the same was the actual date of birth of the disease. Full stop. He has also referred to the trade license which was exhibited, in which a figure 34 has been mentioned, which according to him would be the age of the disease. Full stop. As regards the transfer certificate of the school, comma, he submits that that while exhibiting the same, comma, objections were recorded, and therefore the same cannot be relied upon. And the same was rightly not relied upon by the learned tribunal. Full stop. The certificate of insurance by Peerless also states, which was exhibited as Exhibit 9, also states that the age of disease was 40 years as on 1999. Full stop. The doctor submits that in fact a higher multiplier of 15 has been taken, which according to the judgment of the Honorable Supreme Court in the case of Sarla Verma, reported in 2009, 6 assessment 1 to 1, comma, the actual multiplier should have been 14. Full stop. Para. As regards the income certificate, comma, the doctor submits that both were issued both were issued in the year 2008, which is long after the accident, which was the year 2004, and were issued respectively by the village headman and one organization, which does not have any evidentiary value. Full stop. In this connection, the Learned Council for the insurance company has placed reliance upon the judgment of Oriented Insurance versus so and so, reported in paragraph 19 of which it has been stated that he has also cited the judgment of New India Assurance Company versus so and so, reported in the Learned Council for the Insurance has also submitted that when there are no concrete material to establish the income of the deceased, comma, the minimum wages are to be adopted, and in the instant case, the approach of the Learned Tribunal in holding the income to be rupees 4,000 per month cannot be faulted with. Also, in this regard, the Learned Council has relied upon the case of Kirti versus Oriental Insurance Company, reported in the aforesaid case of Kirti Supra, the Honorable Supreme Court in paragraph 11 has laid down as follows. Full stop. That reliance has also been made on a judgment of this court dated 20/2/2023, passed in MSc Appeal 539 of 2018, within bracket MS Ruchi, where it has been held that minimum wages are to be taken as the standard. Full stop. Para. With regard to the ground of rate of interest, comma, which also the learned council has submitted, that the factor which should be taken into consideration is the factor, the relevant factor which is to be taken into consideration is the current economic scenario. And under such scenario, comma, grant of interest at the rate of 6% cannot be said to be on the lower side. Also, he relies upon a case of the Honorable Supreme Court reported in 2001, US 9, Numa, in which, in paragraph 24 of which the Honorable Supreme Court has laid down that the rival submission made by the learned counsel for the parties have been duly considered, and the material placed for this court, including the record, have been duly verified. Also, there are, as recorded above, comma, the accident and the claim as such was not the subject matter of dispute. Also, the insurance company did not dispute that dispute the fact of the accident, and also had taken up any point on the violation of any policy condition. Also, the dispute is with regard to the quantum, which according to claimants, appellant, is on the lower side. Also, as has been recorded above, comma, the challenge which has been made is on the grounds of the monthly income, comma, the age and the rate of interest. Also, para. Let us deal with the aforesaid respect in seriatim. Also, para. With regard to the age, comma, as per the claimant, comma, the age of the deceased at the time of the accident was 34 years, and only because of the fact that in the PM report, comma, the age was recorded as 45 years, comma, a wrong multiplier has been adopted. The materials which have been relied upon by the claimant, apart from the oral evidence, is a certificate, is a transfer certificate by the school in which the date of birth of the deceased has been stated to be 15/12/1970, as per which the age at the time of the accident would be about 34 years. Also, however, comma, it is seen that the state transfer certificate was objected to. Also, though our tribunal adjudicating a motor accident claim, or this court acting as a court of appeal may not be too rigid in the manner of proof of such certificate, the since the age was specifically objected to, it was incumbent upon the claimant to bring on record other materials to substantiate the age put up. To the contrary, the exhibits which were produced by the claimants themselves would show that the projection regarding the age of the deceased made by them as 34 years would not be consistent with such material. Full stop. The trade license of the year 1987 shows that another contains a figure. What was the figure? 34. No. Contains a figure 34 in the year 1987. Full stop. So even if it is held that the said reference to 34 may not be the age of the deceased, the trade license was admittedly of the year 1987, and even if the deceased is assumed to be born on what was it? That was it. Born on 15/12/2070, at during that time of issuance of the certificate, he was less than
Approx 17 years.
he was less than 17 years of age, which appears to be an unreasonable standard. Full stop. This court has also noticed that the insurance policy by Peerless has also been exhibited by the claimant, and in that exhibit, the age of the deceased has been clearly stated to be 40 years, and the policy and the document is of the year 1999. In view of such category and view of such material, this court may not be inclined to is not inclined to accept the submission made on behalf of the appellant that the tribunal had erred in taking the age of the deceased to be in the slab of 40 to 45. As regards the income, the claim made on behalf of appellant's claimant is that the deceased was earning an amount of rupees 15,000 per month and was the sole breadwinner of the family, consisting of 7 numbers of dependents. Full stop. The Sri Lal, the learned counsel, has also tried to impress upon this court that taking into account that the deceased had also made certain investment comma, assuming an income of rupees 4,000 per month would be on the lower side. Full stop. Para. Juxtapose, comma, the two documents, juxtapose, comma, the two documents have been, the two documents which have been, which was proved, which was exhibited in the tribunal may not be conclusive to, with regard to the income, as both these documents are issued by persons who do not have such authority. This court is in agreement with the argument advanced by the doctor by relying upon the by relying upon the case law that such evidence or such documents shall not have any evidentiary value. Full stop. However, comma, even without those documents, comma, when there is the categorical assertion by all the witnesses regarding the monthly income, which was said to be 15,000 per month of the deceased, and also taking into account that the deceased was the sole earning member of a family of 7 dependents, comma, the finding of the learned tribunal regarding the finding and conclusion of the learned tribunal to hold the income of the deceased to be rupees 4,000 per month appears to be on the lower side. Full stop. Para. With regard to the interest part, comma, this court has noticed that section 171 of the Act does not prescribe any particular rate of interest, and such rate, and it is the settled law that such rates are normally to be awarded from the date of filing of claim petition. Full stop. Awarding of interest, therefore, would lie on the discretion of the tribunal, and this court, being an appellate court, is only required to see whether such discretion was exercised in a judicious manner. Full stop. The para. Sri Lal, the Learned Council, has submitted that in all other similar enactments, comma, the minimum rate of interest is 12%, and therefore grant of 6% is absolutely on the lower side. Full stop. He has also placed a number of case laws as recorded above, in which reference has been made to the Upahar tragedy case, as per which 9% interest has been considered to be a standard rate of interest. Full stop. Considering the above facts and circumstances, this court is of the opinion that the rate of interest is liable to be enhanced. Full stop. Para. After consideration of the aforesaid facts and circumstances and the law, and taking into account the case law cited, comma, this court is of the opinion that interest of justice would be served if the monthly income of the deceased, which has been held to be 5,000, is enhanced to rupees 7,500 per month, and the rate of interest is enhanced to 9% per annum. Full stop. It is, however, clarified that this court has not from interfered with the finding of the tribunal as regards the date of application of such interest, which would be from the date of filing of the claim petition. Full stop. Accordingly, the award stands modified. And have you made please make the calculation. We'll put it and let it come from both the sides.
Right.
Okay.
That's it. That should be, filial consortium will also come in, my lord.
Which one?
Consortium and love and affection, my lord.
Now,
Lordship, it has to, my lord. The Supreme Court has clarified in 2020 that
you have not said anything on consortium, love and affection.
because this is settled principle of law. My learned friend will agree to that.
Settle, but he has not argued.
Okay,
It's
you
settled
will add one line.
We'll provide you.
Provide the calculation and have one calculation by both sides.
Yes. We'll sit and
Uh,
talk it out.
Yes, and at this stage, and at this stage, Sri Lal has also raised the aspect of grant of compensation on the heads of consortium and love and affection as laid down.
Your Lordship, love and affection will not come. As per
Consortium.
Consortium.
Consortium. That will not.
Parental and filial compensation.
Consortium as laid down by the constitutional bench in the case of Pranay
But not constitutional bench, my lord. Just clarify it.
Three judges bench. And Pranay City it was done.
No, my lord. Pranay City, it was not granted, my lord. Thereafter, in case of Magma, it was granted. And 2020 Supreme Court, my lord, it has clarified it should be granted, my lord.
Pranay City, but it has said
No.
all the head.
No, my lord. Pranay City consortium was not
Only
granted.
said
my lord.
about consortium.
Why?
As laid down in.
We'll give that citation.
Therefore, the amount at the rate of will be required to be included in the award. Then we'll
make the calculation.
Your Lordship, another observation that the amount of.
Have you
old-
deposited any amount?
Yes, I think they've
Yes,
received.
We have
because
received the amount.
they've
The
received.
earlier amount we have received.
Unsatisfied by
Okay,
that.
okay.
So
Um,
this amount shall be deducted. from the
Obviously,
enhanced.
it is
See, to
needless to,
automatic-
it is needless to state that the interest as but that amount you are paying 6%, isn't it?
Yes, that is.
Interest should be on the on
They will make the calculation, whatever.
make the calculation.
They will make the calculation, whatever deduction is there.
And you may give tomorrow morning also. Take your time. Don't hurry.
It take 5 minutes, my lord, I believe. You can done it now.
Itu award to calculation.
Obviously.
Item number 19, it has had date for yesterday and fixed today. Today may not reach it, my lord. That may be fixed on next week, my lord.
Okay, we'll fix that. We'll fix the he'll give us the 19 was which matter 19?
Hello?
Which was this matter, Mr. Sharma?
Item 19, supplementary list.
Which was, oh, that pagination.
Hello?
Pagination. Pagination.
Oh, yes. my lord.
You have corrected it.
Yes, right. Maybe fix on next week. my lord.
Okay, we will fix it. Yes, we'll give it. Please get the date from our court master. Hello? Please get the date, ask your senior, he'll give the date. Court master will give the date.
period or judgment. It was dismissed, therefore, appeal was filed against that judgment.
Yeah, for the other side.
Me,
Just a minute,
my lord,
just a minute, just a minute.
That my apology, my lord. One clarification is required, my lord. The deduction, my lord, part will be as per the plenary judgment, my lord. Constitutional bench judgment, my lord.
Which one?
The deduction part, my lord. Money 25% is to be multiplied, added, my lord. And as per plenary, 1/6 is to be deducted, my lord. In terms of the constitutional bench judgment, my lord. Depending upon the number of dependency, my lord.
That you make the calculation. That those are mandate of law.
Sir.
You make the calculation. Don't hurry up with the calculation. I'm just telling you, not, I'm telling this with some purpose. Think over. Give it tomorrow. Give it tomorrow morning. No problem. We're taking for disposal.
in this case,
Just a minute.
matter is very simple. But
That-
this case happened from the same dag and patta.
You are for?
I am for the, my lord, here appellant, my
No,
lord.
appellant is what?
Defendant in the.
Appellant is the
two-
defendant.
Yes, my lord. Respondent was the plaintiff.
Okay.
That was,
Suit
suit
was
was
for?
dismissed, my lord.
Suit was initially
Dismissed.
dismissed.
Suit was dismissed.
Then it was
Then they
reversed.
have filed appeal.
Ap-
Appeal
Reversed.
reverse the judgment, my
Okay,
lord.
suit for?
My lord.
Suit was for?
Suit was for declaration, right, declaration of right title interest, right title, first position and injunction. My lord.
First position, recovery or confirmation?
Recovery, my lord,
Recovery.
actually, my lord.
Recovery.
Right.
First position. And injunction.
And injunction, first position and position.
Okay. Yes, what has happened?
May I read the, my lord, plaint, my lord?
Now you can tell us what has happened. Have you seen?
My lord, plaint. Because, my lord, what happened, my lord, in this case,
First you tell us the facts, then you will read the.
my lord, yes. I am the one, my lord, schedule land is dark number covered by patta number 66 old and dark number 7 new and 223 is old. And there are pattadars, my lord.
There is one plot of land.
So same patta, from same patta we have purchased. I have purchased and from same patta he has purchased.
There is
I am the purchaser, I am the former purchaser, my lord, earlier purchaser, I have earlier purchaser.
the same plot of land.
Same plot of land from one co-sharer I have purchased, from another co-sharer they have. Yes,
Your sale deed was registered.
yes.
What happened, my lord? Originally.
Now we'll come to you. Your facts, let us see. You
My
get
lord.
your chance. If there's anything to differ, we will hear you.
In the name of my wife, in the name of his wife, he has purchased 3 kotha of land. And in the year 2002, my
Why wife is not a part?
wife died. In the meantime, she died.
Okay, who wife
And
passed away.
other legal heirs were not made.
And tell, we have not,
Only the husband was,
Mr. Sharma, tell us the facts in seriatim. Go slowly. We'll not be able to.
my lord,
See, you had, your wife had purchased
purchaser, 3
Land.
kotha of land.
3 katha.
Yes, my lord.
Wife of defendant.
Yes,
Wife of defendant purchased
3 kotha of land.
3 k.
It's put by 2 registered shall deed, my lord. By 2 registered shall deeds,
Okay. Who was your vendor?
my lord.
Who was your vendor?
Vendor, my lord, one Aruna Das Gupta. through her attorney was also same, my lord. That is, who has sold it, he is also same person, my lord. Through attorney, it was sold, my lord.
Name of the attorney?
Name of the attorney, my lord. Asit, my lord. Tell the detail, my lord. Asit Kumar Bishwa, Animesh Kumar Bishwa. Animesh Kumar Bishwa.
Okay, there, you had purchased, your wife had purchased 3 katha of land
Three kata
by
by sell
2
it.
registered till deed.
True registered sell it.
What was the description of the land under?
Yes, my lord.
Under Doug number?
And the dark number, my lord. Dark number 66. Dark number 7 new, 203 old. Patta number 66 new, 2 old. Village Bali Jana, Circle Gwalpara. District Gwalpara.
Thereafter,
Thereafter, what happened? I have purchased from Animesh Gupta. And
Animesh
they have
Biswal.
purchased, my lord, Animesh,
Biswal.
Animesh, Anuma,
Aruna
Aruna
Das
Das
Gupta.
Gupta. Aruna Das Gupta.
Okay.
And he has purchased co-sharer, namely, see, his name is,
When was the sale deed registered?
my sale deed was registered in the year 2002. Deed number, my lord.
Date.
Date 2 deed, 125, 2002,
20,
25,
28th of May 2002.
20th May of 2002.
And
Another sale deed. My lord. Plain.
We'll submit it tomorrow, my lord.
complete the calculations today. And make it today, finalize today, give it tomorrow. And the second till date?
Second deed, 19-1, 2021, and section 16-5, 2002, and 25, 2002. 16-5,
16/5 and 25.
25. Two sale deed, registered sale deed.
Yes.
And got possession. I am holding that land.
And they purchased from?
They purchased from Animesh Biswa's same attorney, my lord, but the Jawaharlal co-patadar is Jawaharlal Das Gupta. His share, from his share, they have purchased 10 less of land.
You had also purchased 10 lechas.
I have purchased 3 katha. 3 katha, they have purchased 10 less.
Purchased 10 lechas from
Jawaharlal Das Gupta.
Jawaharlal Das Gupta.
I, through his attorney.
Asim. Animesh.
Attorney same, my lord.
Animesh.
Animesh.
Now, what is the date of their sale deed?
They are selling daily, my lord. Sale deed. 7, my lord, 17/1/2005.
2005.
5.
And do you say that this, how many letters they got?
10 less.
10 letters.
10.
10.
10 less.
This 10 letter is within your 2 katha, 3 katha.
Within your, that is my plea. That is the plea that was trial court has held, that it is within that.
And this 10 letter is also under dark 7 of
Same dark, same pattern. Tag number 07, 2003, new 2003 and 66, same document. Sir, whatever, my lord. In
Now,
the
why did they institute the suit?
schedule,
Why was the suit instituted?
my lord,
Why did they file the suit?
they filed the suit in the year,
No, why?
my lord, I have enclosed their land,
That is
10
the
less of
allegation.
land,
That is the allegation.
that is their allegation.
But you were already there
Yes, my
by
lord,
virtue on the strength of two
Yes.
tail deeds.
I'm not,
And when is his contention that when he purchased the plot of land in the year 2005, he saw that there was encroachment by you,
no,
and therefore he had filed the suit. That is the allegation.
no, in the year 2007, I have made construction in my land, that within 3 katha of land.
Suit was instituted which year?
My lord,
Suit is of which year?
suit is 2007, my lord,
Oh, 2007.
in the year 2007.
What is the number?
77/2007.
Oh, allegation is of 2007.
Yes, sir.
Of enforcement.
Of enforcement.
Yes, what happened thereafter?
My lord, thereafter what happened, my lord, they have examined four witnesses, including one official witness. PW1 deposed that only PW1 has given evidence, vital evidence.
Witness.
PW1 has given evidence that his land was enclosed by me. And 2, 3, they
PW1 is the plaintiff.
plaintiff. 2 has not come for cross-examination. He has filed only.
Who was PW2?
PW2 is my lord.
Madam, have your seat? Don't sit like this. Don't stand like this. There are seats vacant.
My lord. Copy of the, my lord.
PW2?
My lord, PW2 is my lord, I have not.
No, who was he?
My lord, he is the, PW2 is his witness, my lord. PW.
Understood, but how is he connected?
He has filed as evidence in chief.
Understood.
But
how was he connected with the proceedings?
Proceeding, my
Who
lord,
was he?
that is.
Relative.
My lord,
Relative or something.
my lord, actually.
But he
my
did
lord,
not come for cross-examination. That is what you want to say.
No, no, he
He
has
did
not
not
come for cross-examination.
So his witness was expunged.
Expand, my lord. That is, that he was expand. And PW3 also did not, has deposed that he knows nothing. That is the
PW3 says he knows nothing.
nothing, my lord. In the judgment itself is reflected. I have not obtained the copy of my lord, cross-examination and
Okay, doesn't matter. Then what had happened?
my lord, only 4, who is the official
And-
witness, sub-register office.
Yes.
He came and he deposed that he has sold, plaintiff has purchased the land, but I have not seen the power of attorney, the person, seen the power of attorney by which the main defendant, main owner has told him. He has not seen the power of attorney. He has come from official witness only. PW4 is the official witness from sub-register office. Well, issue number 3 is the vital issue for of the trial court. That is the main issue, my lord.
Yes. What was the
Issue was, my lord, whether the plaintiff has right title interest over the suit land or not. That is the vital issue that was discussed, my lord, elaborately, and other issues were not discussed, my lord. That was in the issue number 3, whether the plaintiff has acquired any right title interest over the land. My lord, issue number 3 is discussed here in page number 56, my lord.
56?
36.
36.
36. In our page 33. Issue number 3, my lord. Other
Where
issues,
where is the type copy?
type copy, my lord. First type copy, my lord, this is page number 25, my lord.
If I, number,
Is here this issue, my lord, may I read that? That is the only issue, my lord.
yes,
My lord. PW1 being the plaintiff stated that shoot line is a part of the land, measuring 4 bigat 8 lesa, or 4 kotha 8 lesa, situated at Pahartoli, GB town so ward number so covered by dag number so ward photo number so under Bali Jana circle belonging to Jawaharlal Das Gupta, Kolkata. He stated that as Jawaharlal Gupta stay outside, so he executed a special power of attorney in favor of the pro forma defendant number 2,
your name is
Onimesh Kumar
Dharmendra
Biswas.
Biswas. Your name is Dharmendra Brahmo
No, man. Investor Stoica. I purchased the same sort of
from
land
Dharmendra.
from
So there was another vendor in between.
Well, first one, my lord, Brahma has purchased,
Dharmendra
thereafter,
Dharmendra has purchased
my lord.
in 2005. Okay,
He stated that Jawaharlal Gupta stay outside and executed. And Animesh Kumar Gupta in respect of the entire line on 12/3/02 to look after 202 entire line. He further stated they paid said Animesh Gupta on the strength of the said power of attorney sold the land to Dharmendra Brahma. Animesh Kumar Gupta, first sale, my lord. White sale, registered sale deed number 12, dated 7/1/05. And who in turn sold the same to him, white sale deed number 1647. That is on 19/5, it's
it's a 17/1/2005 years.
2005, first sale deed. Well, Your Honor, first sale deed was Dharmendra Biswas,
Dharmendra Biswas was of 7/1/2005.
7/1.
When did 25 from Dharmendra?
From Dharmendra Biswas, Dharmendra Brahma, from
When?
Dharmendra Brahma, he has purchased.
When?
In, that is,
Okay, we'll find it.
yes.
Yes.
He further stated that after hearing purchase the suit land, he got possession over the suit land, enjoyed the same till 1/7/2007. That is, he claimed it to be disposed on that day. When defendant encroaches upon it and started construction of the suit land. He also exhibited documents in support of his person. That is Exhibit 1, wherein certified copy of sale deed by which purchased the suit land. Exhibit 2, which is also certified copy of sale deed by which Dharmendra Nath Brahma purchased the suit land.
Alright. Exhibit 1 is certified copy of sale deed by he purchased the suit land. Exhibit 1. And exhibit with certified copy of sale deed by which Dharmendra purchased. Dharmendra's purchase exhibit 2.
Dharmendra sold him, sold the land.
Exhibit 3 is the Jamabandi.
During cross, he stated that he cannot say exactly the total area of land under dag number 12. He further stated that total area of land purchased by Rosemary, that is the wife of the defendant, was 3 katha. He admitted, I have purchased 3 katha of land,
During process, he cannot say exact.
which
The
includes
total assessment cannot say exact area of
the suit land. That is here, madam. Beautiful. Which includes the suit land. He also stated that he had not met Rosemary party to the suit because she had expired and no more. He again stated that he purchased the suit land in the year 2005 and the person from whom he purchased the suit land, that is Dharmendra Biswas, also purchased the suit land on 2005. On 2005, after 10.
You were made a party or okay, you because
Yes, my lord, I am defendant, my lord.
okay. Then
PW2 examined, but he could not cross-examine as plaintiff failed to come.
expand.
Failed to come. PW3 stated that he do not know who is the owner of the suit land. She also, my lord. PW4 is the official witness. He stated same as PW1 in chief. However, in cross, he stated that he was not present in GLP sub-register office, Gwalpara sub-register office in the year 2005. And that time, Dharmendra Brahma used to work as UDA in the office of the sub-register Gwalpara. He further stated that he does not know, does not have personal knowledge whether the seller has shown any power of attorney at the time of executing sale deed. My lord, that is his version, my lord, official. He also stated that sale deed number 47 was executed just after 12 days of execution of sale deed. After 12 days, he transferred to the transfer.
Dharmendra told to plaintiff after 12 days.
After 10 days, 12 days. He further said that there is a value of getting a non-employment certificate from the office of the solicitor to find out whether the land is free from enclosures or whether it is already sold out. He also stated that he do not know whether the Dharmendra had obtained any non-employment certificate or not. From the above, it is found that version of PW is not corroborated, rather it is self-contradictory. PW1 himself admitted in cross that suit land is included in the land purchased by the defendant. Who evidence in chief, defendant on the other hand also stated that his wife purchased the suit land on so and so date from Onimesh বিশ্বাস by two registered shielding respectively prior to suit land being purchased by the plaintiff. He further said that the name of his wife is also recorded in the reviewing report of rights as Patara. From above, it is Jamamandi, it is in the records of rights. From above version, both sides, what is transferring is that the suit land is a part of the part of land purchased by wife of defendant Rosemary, which is also admitted by the plaintiff thereof in his deposition during cross. Further, the evidence on record shows that Rosemary purchased the suit land in the year 2002, 3 years prior to plaintiff. So, and her name is also recorded in the revenue records of rights and as evidence in Exhibit 3. So the person who is prior in time is prior in right. Further, power of attorney holder Onimesh has already sold the suit land to defendant wife in 2002, and he has transferred the title and ownership of the suit land to the defendant wife. So he cannot again sold the suit land to other person, or he had nothing left to transfer. He himself has no right to transfer. Hence, from the above, it is clear the suit belonging to Rosemary. This issue is decided in the my lord. And other issues are, my lord, from the other issues are negative. My lord, what even trial court has taken a view, my lord. Trial court. Issue number 3 is sufficient. In trial court also. Well, my
Now, why the first appellate court has reversed judgment?
my lord, in the judgment, in the western side of my boundary, I have mentioned that Aruna Dasgupta has remaining land because she has 4 katha, 8 lesser. She has.
You had purchased 3 katha.
3 katha. She has purchased 4 kathas, 7 lesser, 8 lesser. They are divided, 7 lesser. And out of that, after purchasing that 1 katha, 7 lesser with her. That's why in my sale deed, her name is in the western side. That is in my sale deed. But that was not exhibited because I am the defendant, my lord. It is the duty of the plaintiff to prove his case, my lord. He could not prove his case. That's why I have not exhibited my document. But in the trial court, my lord, the Xerox copy of I have submitted one Xerox copy in the court as a
Copy of what?
my registered sale deed, that 2 sale deeds. And on the basis of that 2 sale deed, in the basis of my lord, I am going that part also. On depending upon that 2 basis, that is there is dispute of boundary. That's why the land which is suit land is different from the land of the defendant. That is the view of the appellate court, my lord.
So in the schedule to the plain,
My lord,
in the schedule to the plain,
my lord,
the plot of land has been described.
my lord.
Now,
That's
in
correct.
the plot of land described,
Yes, correct.
what were the boundaries of these 10 lectures of land?
10 lessons of land, my lord, here, this is mentioned. My lord, north is Kalyan Sarkar and Aruna Das Gupta.
Where is the schedule?
Schedule is, my lord,
Where is the plain?
explained in the page 15. And the judgment itself, my lord, appellate court judgment, it is reflected. In the trial court judgment, it is not reflected because
Is 15.
page 15. Page, my lord, page 15, yes, my lord. Last line, my lord.
No, we are not on the schedule of the, we are schedule of the plain.
Schedule of the plaint, my lord.
Plain.
Yes, my lord. I am.
Plain is there or not? Plain
Yes, I am in its plaint. Schedule of the plaint is there. my lord. Plain is 51, page 51, my lord.
you want.
Plain, schedule of the plaint is
Yes, yes.
land measuring 10 lecture, which is situated at Pardal so, my lord. North, Robin Nath. South Road, East, Rosemary Ragha. There, Rosemary Ragha.
Your wife,
Yes,
your wife.
yes. Rosemary Ragha. Sukhmoy De. But my claim is this: in the north, there is in the, my lord, western side, still the seller has still some land, that is 1 kata 7 lesa. She is holding. Then that's why in my sale deed that was reflected. But in his sale deed, he has not reflected the land of Aruna Das Gupta. He reflected my land. Aruna Das Gupta land is there, my lord, but that was not reflected. Sale deed was prepared like this. Well,
Why was the reversal done by the appellate?
appellate court judgment, my lord, is page number, my lord.
Starts at page 8.
7, my lord.
Yes.
My lord, appellate court judgment also issue number 3 was discussed, my lord.
Yes, let us see.
My lord. Issue number 3. 3 is sufficient, my lord, because issue number 3, as page 14. The third issue deals with question whether the plaintiff has acquired any right or interest of arbitration in support of this claim. Plaintiff or alleged. PW1 Dimbesh Soikia, who is the plaintiff?
You are reading at page
Page 14.
1, 4.
Issue number 3, my lord. I am reading issue number 3.
1, 4.
1,
Yes. Issue number 3.
The PW1, Dimbesh Soikia, who is the plaintiff in this evidence, stated that Jawaharlal Dasgupta was the owner and possessor of a land measuring 4 kata, 4 lesa, 8 lesa, covered by the number, same the number. The PW1 stated that Jawaharlal Das Gupta executed a power of attorney so and so in favor of the defendant number 1, Animesh Kumar Biswas, for the entire plot of land. Animesh Kumar Gupta, power of attorney holder. He is power of attorney. He is also my power of attorney, or
Understood.
as well as his,
Yes.
but he was not examined as a witness. My lord. Sold a plot of land made 10 lesa out of the total land measuring 4 kata 8 lesa, covered by dag number my lord. To the performer defendant number 2, Dharmendra Nath Brahma, white cell lead number so. The performer defendant number 2, Dharmendra actually, Nath Brahma, after purchase got delivery of possession of the said land and enjoyed the same peacefully. He subsequently sold. Thereafter, on 19/1/2005, the performer defendant number 2, white cell lead number so sold his purchased land to the defendant, to the Dimbesh Society. He is plaintiff. After
Just a minute. Dharmendra had purchased on 7/1/2005.
Yes, my lord.
And on 19/1/2005.
He sold again.
After 12 days,
He sold
he
plenty to
sold
the
to
plaintiff,
the plaintiff.
plaintiff. My lord. And thereafter plaintiff, my lord, sold his purchased land to plaintiff, he basis again. The PW1 further stated that after purchasing
Just-
the.
just- just- Yes.
Well, PW1 further stated that after purchasing the suit land, he obtained delivery of position of the suit land and also marked the boundary by putting pillars. The PW1 stated that on 2/7/2007, the defendant engaged some laborers and started to erect permanent structure. That is the date of on the suit land, and being asked by him on 10/7/2007 to stop construction of the same, did not comply. The PW exhibited the certified copy of the sale deed marked as Annexure 1, by which he had purchased the suit land from the performer defendant number 2, Dharmendra Nath Brahma. He also exhibited the certified copy of the sale deed number as Exhibit 2, by which the performer defendant number 2, Dharmendra Nath Brahma, has purchased the suit land from the performer defendant 1, Sri Animesh Kumar Vishwas. The PW1 exhibited the certified copy of Kheraj Miadi Jamamandi also, that is Jamamandi, same Jamamandi. We have also Jamamandi of 2 bigha 2 katha 6 lesa. 2 bigha 2 katha 6 lesa.
Both Jawaharlal and Arunadas names are recorded.
Recorded. They are there. He is also recorded.
Please read.
My lord.
Please read.
My lord. From perusal of the exhibit 3, it appears that the names of Jawaharlal Gupta and Aruna Das Gupta are recorded in serial number 2 and 3, meaning thereby that both of them had held lands in the state Patta and Dak. The plaintiff's case is that he had purchased land which was sold to him by the performer number 2, Dharmendra Nath Brahma, who in turn had purchased it from the performer defendant number 1, Animesh Kumar Vishwas, in the capacity of attorney holder of Jawaharlal Das Gupta. The wife of the defendant, Rosemary Rabha, on the other hand, had purchased the land from the performer defendant 1, Animesh Kumar Vishwas, in the capacity of attorney holder of Aruna Das Gupta. The defendant, in the course of trial, did not exhibit any document. My lord, that is the sale deeds by which Rosemary Rabha had purchased land from Sri Animesh Kumar Vishwas in the capacity of attorney holder of Aruna Das Gupta. From the facts, as discussed above, it has become clear that Animesh Kumar Vishwas has sold the land belonging to Jawaharlal Gupta to the performer defendant number 2, Dharmendra Nath Brahma. And
did you adduce evidence or not?
Yes, evidence I have given, my lord.
You had adduced evidence?
Yes, I have given evidence, my lord. They have given 4 evidences.
No, your evidence.
Yes, I have given evidence.
You adduced evidence.
Evidence.
Did you produce the sale deed? No.
My lord, because I am defendant, my lord. I have to I have to file my case. That is not, I am occupying my land only. For that, I have shown my photocopy of sale deed before the court. But that was objected by them.
No, weren't you required to show your prima facie, show your right to the sale, because they are treating you as an encroacher.
Encroacher, yes.
The moment the allegation is there, what would be the normal reaction? That, see, I have a sale deed in my favor.
My lord.
You have not done that. That is not.
Sale deed not exhibited, my lord. I have not.
I think that will be a burden which you have to discharge.
My lord.
It is not a question that unless they make out a case, they have made the allegation and they have exhibited certain documents and 4 numbers of witnesses. Whether those witnesses are reliable or not, that's a different matter.
Well,
but as a defendant, your foremost duty to show how your right is there to occupy the land.
Yes.
How the allegation by terming you as an encroacher is incorrect. That I have this sale deed in my favor and therefore I am the rightful owner in possession. You have not done that.
My lord, that was not done. I have not exhibited.
Till now, there is nothing on record to support your contention that you had purchased land on an earlier point of time, prior point of time, from Aruna Dasgupta through the same power of attorney holder. That may be a fact.
My lord, they have admitted, they are admitting, in the plan itself, they have admitted that I have purchased 3 kutha land. They have admitted, admission, in once it is admitted,
Where in the plain?
in the plan itself it is, my lord.
Where? Okay, we'll come to that. Finish this part.
My lord. Rosemary, on the other hand, my lord, the plaintiff's case is that he has purchased land which was sold by him, performed with Dhanendra Vishwarma, who in turn had purchased it from the performer defendant one, say Animesh Kumar Biswas, in the capacity of Jharlal Gupta. The wife of the defendant, Rosemary Rabha, on the other hand, had purchased the land from the performer defendant one, say Animesh Kumar Biswas. That is title appeal also, appellate court also accepted, no? In the capacity of attorney holder of Aruna Dasgupta. The defendant in course of trial did not exhibit any document, sale deeds by which Rosemary Rabha has purchased land from Animesh Kumar Biswas in the capacity of attorney holder. Aruna Dasgupta, from the facts as discussed above, it has become clear that Animesh Kumar Biswas has sold land belonging to Jawaharlal Dasgupta to the performer defendant number 2. Dhanendra and land measuring to Aruna and land measure belonging to Aruna Dasgupta to Rosemary Rabha, same attorney holder. The land purchased by the performer defendant number 2, Dhanendra Nath Brahma, by sale deed number which was subsequently sold to plaintiff by Dhanendra Brahma, is bounded by North Kalyan Sarkar, Aruna Dasgupta. Here they have shown north, south road, and east Rosemary Rabha, and west Sukhmay Das. My lord, question is Rosemary land is there 3 katha, that is admitted, but for that, my lord, Amin commission was to be appointed. Whether land is occupying, the 3 katha he is occupying or not, and 10 lesser he is occupying or not, that is to be. Amin commission was not appointed. They have not applied for Amin commission also.
Under 75.
My lord.
75.
Order 26, my lord, commission. That was not 75, section 70.
75.
Yes, it was not applied. They have not made field verification of the land also. My lord.
Order 26.
Yes, my lord.
Application for issue of the powers under 75 was not invoked.
My lord.
There was no application under 75 for
They are the
any
plaintiff,
commission.
my lord. They have to apply for Amin commission, but they are admitting that I am holding 3 katha of land. They are not disputing. That's why, my lord, that is the. But my land, they included the suit land inside my land. But DW1, who is the defendant in evidence in chief, very tactfully avoided the boundary of the land purchased by his wife, but stated the patta land tag number and sale deeds number and date of purchase, and also did not exhibit the sale deeds. The official records of the sale deeds were also not called for by the defendant. The DW1, my lord, only defendant, it is not duty of the defendant, my lord. He once admitted he did not have to pass. That's why.
Where is the admission?
My lord.
Where is the admission?
In the plant itself it is.
Let us see the
My lord. My lord.
Let us see the cross examination and the chief and cross of PW1.
PW1. My lord. Only it is reflected in the, he has, it is reflecting the, my lord, judgment also, trial court judgment. He, PW admitted that 3 cutoff land is put, suit claim.
PW1. PW1 is investor.
So you can.
Sorry, There are statements in the cross examination
Yes, my lord.
to the effect that it is not a fact that Rosemary purchased the suit land from Animes by sale deed number so and so dated 16/5 and sale deed number so and so dated 25. He says it's not a fact. Then he says the total area of land purchased by Rosemary was 3 katha, which include suit land. I have not made Rosemary party in the suit as she had expired. I purchased the suit land in the year 2005. Armando purchased suit land in the year 2005. There is an admission in the cross examination.
My lord,
This admission would be vital. The total area of land purchased by Rosemary was 3 katha, which include the suit land.
my lord, not a fact.
It is not a fact that sentence is ended. It is not a fact that Rosemary purchased the suit land by from Animes so and so or sale deed number so and so. This is a dot. That's the new line. The total area of land purchased by Rosemary.
As per my understanding, my lord, the line is continuing, my lord.
There is no continuation. We have the original here. There is a full stop here.
My lord, my
It's not a question, it's not left for interpretation. Yes, it looks inconsistent with the first line, but there is a categorical finding.
lord, that was, later on in appellate court, my lord, discuss, my lord, number 3, my lord. That is continuing, my lord. That part, my lord.
In appellate court, we have just read.
No, no, my lord, just continuing, my lord, that part, regard, a senior reading, my lord, page number 6, page 6.
Okay, we'll see that, but this is something very vital.
My lord. In the latter part of the cross examination, my lord, the civil he can defend, my lord.
Where is the plaint, Mr. Sharma?
My lord, plaint is, my lord.
Plaint.
It is 48, my lord.
48.
Onimesh Kumar Biswas was made performer defendant, but he was not examined. He is the seller of that, both of us. I please, my lord, I am holding
Just a minute, just a
3
minute.
katha. I have purchased that, must be sufficient for me.
Exhibit is the Jamabandi, it had the name of Jawaharlal.
Yeah, all, my lord. Pattadas, my lord. Jawaharlal,
Did you apply for your correction of record? No. Your name did not come up in the Jamabandi. Your name had come up.
not, he don't,
His name, did your name come up?
yes.
Was your name mutated?
Mutated, my lord. My name is mutated. It is reflected in the judgment also.
Rosemary is there.
Yes, yes, my lord. Yes, in the Jamawandi, it is reflected in the.
Okay, we'll have to continue tomorrow. Mr. Kotoki, can anything be done today?
My lord.
We'll have it tomorrow with continue.
Tomorrow, my lord.
Because today it cannot be possible. Also the other side,
Other side,
where is Madam? Yes, Madam Devi. Today it may not be possible. We have it some other fixed date, but ask him to be there.
on
Review petition, we don't like to keep matters pending at review.
on 17, my lord.
17 August.
August.
Madam.
There is a matter, item 59 of the hearing list.
No, let us pass some orders here.
On 17.
Paucity of time may not permit the matter to be taken up today. Para to the Kotoki, the learned counsel for the opposite party review petition, opposite party writ petition. Submit that there is urgency. Para MSMDV is present for MDV learned counsel is present as instructed by MS3 D. Nath, learned senior grant officer, as agreed to by the parties based on
17, my lord.
17 August.
Well, item number 10, is 2/2001. So it will be taken on Thursday. I have taken the concept of.
Who's for the other side?
Sahewala. I have taken.
2001.
No.
2000. Yes, madam, what is your matter?
Item number 16.
16.
16 and 17.
It's 23rd August 2016. In item number 16.
Insurance company. Appeal by whom? 17 and
16 and 17.
Mr. Goswami is there.
Yes.
Arising out of the same incident.
No, Lordship. Not 10
What are
August,
different
different items.
I am only in 16.
And 17?
17.
17.
Or 59.
17 BK Das, Aman Khan. You will have a date, 16, which date are you?
I am
23rd.
23rd. Uh, 16, right? Paucity of time. It's a 2020 appeal.
Yes, Lordship.
Paucity of time may not permit the matter to be taken up today. Put up as agreed to by the parties list on
23rd August.
23rd of August. And Madam 17,
17, Lordship, we are for the appellant and respondent, I don't,
when do you need? Is there any urgency?
not.
Paucity
such,
of time
Lordship.
did not permit the matter to be taken up today. Registered to release this case after 1 week, after
Yes,
2 weeks.
yes, Lordship. Much obliged.
Item 15 of the portfolio is pursued. There are some urgency that it's a file.
You have said, told us, interest is accruing.
You may kindly take up the matter on the Thursday, Lordship, on 17th of August. Because Tuesday it's 15 hours, Lordship.
Thursday, okay, we'll have, you make a mention in the morning.
Lordship.
Thursday will allow, but Mr. Goswami, you are appearing.
Yes, Lord.
Other side.
Sir, Lordship, I have informed the council, M. Ahmed on for the other side, Lordship. What I have informed that clients has approached him and taken the file from him by the client. So it is their in-house problem, Lordship. Otherwise, it's a old.
Now we'll do one thing. Item number 59. 59 orders of executive. We'll have this listed in the part one man.
Lordship.
If they do not appear, we may give them a chance. In that case, nobody can say that we are not aware of them.
Lordship.
Item number 59 of part two. No? We record your name. Sri B. Goswami, additional advocate general Assam, appearing for the review applicant.
RFA.
For the appellant, submit that there is urgency in the matter and delay is leading to accruing of further interest in this case. So, Sarah, as the chances of reaching this matter, which is in the part two list, is bleak, BLEA, comma, risk is directed to list this matter in the hearing column of the part one list on Thursday.
70.
We can have it on Wednesday also
Also, of course.
and make a mention.
No, sir.
At least before rising, we'll have another date.
No.
That's it. Case of which year?
Money suit is of 2017.
No, April
April 2021. 21.
20. Okay. Thursday.
No, Jamandi, my name, wife, his wife.
Jamabandi was exhibited by the other side.
Other side. Rosemary Rahwa was reflected. My name is not muted.
Doesn't matter. After the demise of Rosemary,
My lord.
by inheritance, your
Inheritance
name or your
is also-
children name will come. But at least Rosemary's name was there.
Yeah. After that, they have purchased, my lord.
You do not do a due diligence exercise. Before purchasing, you did not do due diligence exercise.
My lord, the
Now,
vendor,
before you purchase a land,
My-
aren't you required to ascertain whether the vendor has got the right title and interest which can be transferred to you, or whether it's an incumbent property, whether it's a joint property? And the Jamapandi has names of many other persons, including Rosemary, and there is no distinction which can get carved out from the Jamapandi that out of 3 kathas, only this much is for Rosemary. It's a joint kind of a thing. So, how did you ascertain that this is the land which is being transferred to me in a valid manner?
my lord, the plaintiff, my lord, the respondent, he has purchased the land within a period of 12 days.
That raises a lot of suspicion.
My lord,
You purchased from a person who was working in the office of the deputy commissioner.
Right.
Within 12 days, what was we don't understand this transaction. It appears that these purchase was only to facilitate your purchase. Otherwise, you would have got directly from the landowner, original owner, Jawaharlal, maybe through his power of attorney.
but the vendor from whom the respondent has purchased,
Brahmo,
my lord, his title is also registered, my lord.
understood.
My lord.
But his title has to be traced
Right.
to his vendor,
Right.
who undoubtedly was Jawaharlal.
Right.
But Jawaharlal was holding jointly with Aruna.
Das.
Now, it's a different matter that you may say that maybe the part of Jawaharlal had purchased to your vendor and he had sold it to you. But that is not your case. It was not ever partitioned. There was no differentiation or distinction between the different areas in that common plot.
My lord, the boundaries are distinct, my lord. In the latter part of the appellate court judgment, my lord, page 16, my lord.
We'll continue this.
My lord.
Tomorrow, we'll take a chance. Otherwise, on Tomorrow, Friday,
Tomorrow I have another.
Friday it may not be possible. Huh? Hopefully,
Monday,
54 it. Tomorrow it will not be possible.
my lord, Monday it will be.
Monday we will try. Monday we will try, Mr. Sharma.
My lord,
Monday,
Monday,
because we have heard substantially.
16, my lord, maybe, my lord. On 16th.
16, okay. What is your name?
DJ Hello.
Hello on 16th.
Hello.
Though this matter, though the hearing of the matter had commenced, due to paucity of time, it could not be continued. As agreed to by the parties, whilst the MP Sharma, Learned Counsel, is present for the appellant, Sri DJ Hello, Learned Counsel is present for the respondent. As agreed to by the parties, list on 16th.
In the morning, I want to make a mention.
On 16th.
My lord.
16th is a Wednesday, isn't it?
My lord.
We'll try. We'll try.
Much.